The argument made on behalf of the petitioner is that since the petitioner belongs to the ST category, there was requirement of an academician representing the ST category in the selection committee, and in absence of the same, the selection is vitiated. The aforesaid contention, though seems to be acceptable in the first blast, a careful reading of the entire provision would, however, bring this court to a different conclusion. The selection committee, as noted above, is constituted by various members, including a chairperson. The requirement of an academician representing a particular category to which an applicant may belong would arise only when none of the other members of the selection committee belongs to that category. In the instant case, there is no manner of doubt that the members of the selection committee included two members, namely Srimati so-and-so and Sri so-and-so, who belong to the scheduled tribe category. The said disclosure that has been made by the APSC in the opinion of position dated so-and-so, the relevant paragraph of which is extracted below. In view of the above, the challenge based on the alleged ground that there being a defect in the constitution of the selection committee is fallacious and therefore rejected. As regards the second ground involving marking pattern, this court is unable to accept the contention made that the UGC regulations have laid down the marking pattern. Though the learned senior counsel for the petitioner has referred to the table appended to the UGC regulations in connection with clause 6.1 regarding assessment criteria and methodology, this court finds force in the contention made by Sri Datta, the standing counsel APSC, that none of the four tables are applicable for selection of principal. As recorded above, table 1 is for teachers, table 2 for API calculations, table 3A is for assistant professor of university, and table 3B is for assistant professors in colleges. This court is also unable to accept the submissions made on behalf of the petitioner that only because the selection committee is the same for college principal and professor, the marking pattern would also be the same. This court is of the opinion that in absence of any marking pattern in the UGC regulation, the marks given as per the government guidelines cannot be held to be an illegal process which requires an interference. Learned counsel for the respondent 6 has, while questioning the maintainability of writ petition, has relied upon the cases of Om Prakash and Madan Lal. Though it is correct that no objections were raised before the selection committee on the date of the interview or immediately thereafter before the authorities, the principal laid down in the aforesaid two cases that it would not be open for an unsuccessful candidate to challenge the selection process may apply. However, without even going into the aspect of the matter, this court is of the opinion that the grounds of challenge the writ petition are on absolutely weak footing and therefore those are rejected. This court is also reminded of the fact that while exercising extraordinary jurisdiction under Article 226, it is the decision-making process which may be the subject matter of adjudication, and in the instant case, no apparent flaws have been noted in the decision-making process in which the respondent 6 has been selected for the post of principal. In view of the above, writ petition stands dismissed, interim order vacated, record the return back.
My lord, in item number 1, I seek permission for playing a video of less than 1 minute. I want to play video, lordship. 8, item 8. It is less than 1 minute.
Why?
Because lordship, case of the fact is that the plaintiff sold the land. Now she filed the suit that she never executed the sale. But the video will show that she visited my residence, took the money.
In this court, are we competent to see a video?
Yes,
This is not a trial court. This is a first appeal. You have to file at least an application, maybe in the form of 41/727.
Lordship,
This amounts to adducing evidence at the appellate stage.
no, only for lordship to prove that.
Let us see first. Let us hear you, then we'll see. We'll take a call.
Okay.
Yes.
May please, Lordship. I would like to mention item number 53 of daily list.
Yes.
I have been instructed to withdraw this petition.
Sri N. Sharma, learned counsel for the petitioner, submits that there is instructions not to press this application. Put up. The application accordingly stands dismissed as not present.
Deeply.
May please, Your Lordship. I pray for listing is here. We have filed it on 27th.
Motion.
Motion.
When do you want?
Friday. Okay.
Right, please, Your Lordship. Your Lordship, on Monday, I mentioned a matter for listing as a order stay vacating. I filed a IA for vacation of stay. matter, but today it has come in the orders column as the last item. May I pray for upgradation because the FAO has become infructuous in view of the fact that the plaint has been written and the orders have been ruled 10,
Item number
62 supplementary list.
62 is for orders.
Yes, Your Lordship. I have mentioned specifically in the mention memo to come in the order stay vacating column, or in the, it has come in the orders column, Your Lordship. So it will hardly take 5 minutes. I have
But the
informed-
other side has to be informed.
Yes, I have informed the other side. Your Lordship may take it up at 2, Your Lordship.
We'll not say anything, but we'll take it up this matter. Before we rise, we'll take it up. Don't worry.
Highly obliged.
Yes, Your Lordship, in item.
And
number-
inform the other side. If we get a chance, we'll upgrade the.
I have informed Mr. B.
Yes.
Pathak.
Item number 59, we
Yes.
have filed an additional affidavit yesterday. Lordship, may I permitted to bring it? to
Yes,
your-
59 is admission.
Yes, exactly.
Okay, this is a matter of
Yes, Lordship.
80. Okay. Yes, bring it.
I'd like to mention this TRP mail for listing in the next week, my lord. And
TRP at the what
shall-
stage?
shall-
Motion stage,
No, my lord, orders.
order stage.
Order.
What is the stage now? What has happened?
My lord, notice of motion has been issued, my lord, and
Other side
thereafter-
has appeared.
No, not appeared, my lord. No, therefore not listed, my lord,
Okay, have it next week.
next week.
My please, Lordship, similar prayer, Lordship. In my, it is my MSCT case, Lordship. Lordship, I am a respondent claimant, Lordship. So I have received the notice and filed the OCLA now, but till date, Lordship, it's not,
But the amount has been deposited.
no, Lordship, not deposited.
Appeal has not been admitted.
Lordship, it is a, sorry, Lordship, it is not a MSCT appeal, Lordship, it is workman compensation. Appeal is, has been admitted.
The
Without-
statutory deposit made.
No, Lordship, not deposited, but appeal has been admitted, Lordship. So that's why, Lordship,
Oh.
this matter,
Next week.
high level.
Listing of a condemnation petition, Lordship. It was listed on 17, Lordship. On our prayer, Lordship, it was 50th today, but we have,
Notice is issued,
no, Lordship, yes, Lordship, they have appeared, Lordship.
appeared.
Lordship.
When do you want?
Day after tomorrow, Lordship.
I pay for listing upon civil division for orders in the next week, my lord. In this, one of the respondent died. I have filed the substitution petition.
I have filed.
I have filed already. Obliged.
May I please, Your Lordship, I'm going to mention item number 30. We do.
38.
30.
30. Yes,
We do consent taking from other side.
yes. What do you want? What do you want?
I want to adjourn to the adjourn.
You're praying for an adjournment.
Yes.
You're with Mr. T. Deori. Who is the senior?
Upon the.
T. Deori, yes. Other side has been informed.
Yes,
When do you want?
they want the adjournment.
When do you want? When?
When, next week.
On a prayer made on behalf of the appellant, please after a week. Item 30. Yes,
My please, your lordship. What I pray for listing of a CRP IO, my lord. The petitioner will file this CRP, my lord. Day after.
new matter.
No, my lord, it will come up for orders, my lord. We have filed one injunction petition, my lord. Despite there is a grant of status quo order from this honorable court, my lord. They have carried out illegal constructions, my lord. So there is some urgency, my lord. If your lordship may kindly take up this matter on Monday, my lord. Monday or.
Injunction in a CRP.
My lord, order 39 rule 1 and 2 petition, we have filed one, that injunction has been granted, my lord. That was granted. Despite that, our report was called from the police, my lord. But the police,
Okay,
they,
we'll consider, we'll see whether it's maintainable or not. When do you want?
on Monday or Monday.
May I
Obliged.
please, Your Lordship, I like to mention for listing of a RSA for order.
Why? What RS of which year?
Lordship, 2023,
Orders, what orders? What kind of orders? No, RSA admitted,
Lordship,
admitted.
notice issued,
Thereafter, respondents has appeared or not?
Lordship not appeared.
Then what kind of order are you seeking? Okay, next week. Let's see the service report. Next week. Yes.
Lordship.
Please, Your Lordship. I beg to mention, IA for listing.
IF4.
This is for implement petition for implementing the daughter of the respondent. number
Okay, we'll
20.
have it next week.
Can it be on PD6, Lordship, kindly?
26th.
26 or 28?
We'll have it next week. Give the date, any date. Yes, 26, 28, any date.
Much obliged.
With the consent of the other side, I beg to mention item number 24 of today's daily list, Lordship.
Yes.
Lordship, in here, we actually have to file one additional affidavit. we were directed to take steps through newspaper publication. We have taken the steps, Lordship.
Hmm.
Only the affidavit is there to be filed. Lordship, 1 week time.
The paper publication has been done.
Yes, Lordship.
MSc Mazumdar Learned Counsel for the, have you informed the other side?
Yes, Lordship, I will call the.
MSc Mazumdar Learned Counsel for the applicant submit that in terms of the order of this court, comma, paper publication of the notice has been done, which is required to be put on record by way of an affidavit, for which see 6 a week's time, full stop, para, least after a week.
Much obliged, Lordship.
May it pleases your lordship.
Yes, yes,
Lord, with due consent, I'd like to mention item 44.
yes.
Lord, senior counsel, Mr. H.K. Dekka is not in the country. Right? Till 20.
44.
It is listed because the IAs are for condonation and restoration. Sir.
Okay. You informed the other
We have
side.
informed the other
When
side.
do you want?
Lord, adjournment, Lord.
When?
At least 2 weeks. Lord.
23 matter. 2 to the 14. RS is the 14.
Yes, my lord, there is some argument which needs to be put forth in the.
This is a restoration application.
My lord, they have come forth for restoration of the IS. There is something which needs to be, an argument needs to be put by. Well, my lord, even my senior Mr. B.D. Dekka is not in the country. He went along with me. That's why I seek an adjournment.
A prayer for adjournment has been sought for on behalf of the respondent.
One.
Respond number 1. Full stop, para. List after 2 weeks.
Highly
44.
May it please your lordship. Your lordship, in part 2, item number 18, I am appearing for defendant number 1 in that case. Your lordship, the matter is of 2009. There is a concurrent judgment, your lordship. It's in my favor, but I was appeared on KVA. Now, your lordship, the entire brief was with Mr. late K. Das. So we need to reconstitute the file, your lordship. So may I pay 2 weeks time in that case, your lordship?
We are not passing orders. We may not reach, but you construct your
Your
file.
lordship, until and unless the file is released,
You reconstruct the file. We'll have.
your lordship will appear, we have applied for the certified copy. We'll apply it.
We'll accommodate you. We are not going to pass any orders now of adjournment.
Your lordship,
We
the
make
file
a-
has to be released at least, your lordship, so that the certified.
We have
copy-
said we are not going to take up this matter. Don't you understand?
Yes, your lordship.
Have we said that we are going to take up the matter? We said we'll accommodate you, but we're not passing an adjournment now. Try to understand. Matters of 2009, you are seeking an adjournment. It will be proper if I granted adjournment now.
No, your
We have
lordship.
said we will accommodate you. Reconstruct the file in the meantime.
Deep level.
Yes, next.
May I please your lordship, with the consent of the other side, I beg to mention item number 41, 42 and 43 in the next week, my lord.
41.
42 and 43.
Forty-one is a review.
Review.
You are for whom?
I am for the respondent number 1. H.J. Tamul.
Okay, Mr. Sharma has been informed.
Yes, I have already informed Mr. B. Mukherjee.
Okay. When do you want?
Next week, my lord,
What is your name?
H.J. Tamuli.
You're not on record. You're there. On the prayer of Sri H. J. Tamuli, Learned Counsel for Respondent number 1, matter stands adjourned to be listed after a week. 41, 42, 43. Similar, connected,
Connected, my lord.
1 week.
Obliged, my lord.
Yes, Mr. Mahanta, what is this?
Lord, here the main issue was already settled. The
We
persons-
find there are other cases which have been already disposed of.
Yes.
Review petitions are also there.
That was, my lord, the division bench decision of this honorable court was upheld by the Supreme Court.
Right?
And the persons were directed to be considered. There was a commitment made by the state on the very first day when the motion order was passed, saying that you will have no difficulty to consider the cases of all these persons as and when
Vacancy will arise.
that is already there.
Yes.
And now they come up with the plea that, well, there is no post. Can it happen? That is the issue. Now they have not filed any affidavit here for the last 7, 8 months or 9 months, October, there was an order. Notice was issued in December 2022.
Yes, elementary education, who's there?
Let it be hard, my lord. They are hard pressed because these persons having come back from
Elementary
Supreme Court.
education, Mr. Mahanta, this is normally a bench one. This is specially assigned to this bench.
Exactly.
We need some council of elementary education.
The notice was.
Government
there, my lord.
council,
They know it.
kindly inform us. sir.
They know it. It was notified in the causeway.
No, no, that is okay.
Not that there is that of counsel for the state. This is how they have taken the whole issue, my lord.
You are for whom?
This is the
I'm
difficult.
for respondent, private respondent number 327, your lordship.
Yes.
Now, we are also seated qualified candidates.
I don't think you have any difference of opinion with
We
Mr.
don't
Mahanta.
have any difference. of
You are
opinion, sir.
similarly placed. you
Similarly
said.
placed, your lord. But only thing is that our documents have been verified, but because of an order of this court, further progress could not be made, your lord.
I have elementary education council. Mr. Mahanta, wait
Yes,
for a
my
while.
lord.
We'll have
We'll
this.
be here for a few minutes.
Yes, government council, please kindly inform them. Elementary education.
Lord, I
Yes, madam.
Okay, item numbers 2 to 5, these are all similar petitions. These
Mm.
are again judgment passed by the learned district judge.
Announcing the compensation.
Yes, Lordship. For convenience sake, Lordship may kindly take up item number 5, Lordship.
5V
CRP 104 of 23, Lordship.
104. Okay.
I'll take a Lordship straight away to our written objection, Lordship. That is at annexure 2, page 24, Lordship. There we have raised a specific plea, Lordship.
24
Lordship. Point
Yes.
number 3 of our written objection.
page.
Page 24, annexure 2.
No, that is the starting point. 3 is where?
Point 3, first page, very first page itself. Page number 24.
Point 3. Yes.
That the present miss case is barred by limitation under the provision of Limitation Act 1963, Article 137.
Yes.
Then your Lordship may kindly turn to page number 26. Regarding that the payment was made long before commissioning of the line, Lordship.
Page 20.
26. May I read, Lordship?
Yes.
Point number 2.
Hmm.
That the claimant petitioner has received a total compensation of rupees 14,710 as admitted in the petition towards the loss of seasonal crops and paddy, although 3 Axis Bank checks rupees 7,000 so and so by so and so, so and so, so and so.
Hmm.
The claimant petitioner has received the compensation along with other surface damage compensation estimation covered by separate notices and in total amounting to rupees 14,710. He was paid the compensation as per the government rate, including agricultural department rate prevalent at that time. The crops which were damaged at the time of springing of tower line are seasonal crops, and the compensation which was estimated and given to the claimant petitioner is adequate and reasonable.
Hmm.
Next point, Lordship, that the compensation was received in the year 2011 to 12, and the tower line is activated long ago, and all the records are lying with head office at Gurgaon. It was sent for final audit, many of which are not available in the office of Power Grid Corporation of India Limited, so and so. The time is elapsed more than 3 years and thereby barred by Limitation Act.
When was this announcement application instituted?
It is 2015, Lordship. 2016.
16.
Yes, Lordship. Lordship, may kindly read page number 27, Lordship, point number 5.
Yes.
That the construction of 400 kV tower and stringing thereof is already completed long ago, and enhancement of surface damage compensation.
How has this been dealt with?
Lordship,
How has this point been dealt with by the learned district judge? The point of limitation, where has been it dealt
that
with?
was not considered, Lordship. That plea I have raised in my written objection, but that was not considered. But interestingly, in another judgment which I have annexed as annexure 4, Lordship,
Wait, just a minute.
passed by the same district judge, that point was taken, Lordship, and similar petition was dismissed on the ground of limitation. In the impugned judgment, it was not dismissed.
Let's take a. Issues have been framed at paragraph 7.
The page number 41, para number 11.2 of the judgment, Lordship.
Hmm? Yes,
Page number 41,
yes,
the impugned judgment,
yes,
para number 11.2.
yes.
Discussion was made, Lordship. May I read that part?
Please
Lordship?
read.
Further perusal of the record reveals that although the line was stung prior to 2011 to 12, the instant cases were filed in the year 2016. However, from the pleadings and evidence of the petitioners, it is clear that they had submitted representations lastly on so and so to the respondent authorities, ventilating their grievances, and those aspects have not been denied by the opposite parties. It is argued that the petitioners are rural people, mostly illiterate, and might not know the technicalities of the legal principles. I find force on such submissions. How can that be, Lordship? It is time bar, Lordship. And that point was discussed in the subsequent judgment, Lordship. That I have annexed as annexure 4, Lordship. The same district judge, he has passed the judgment and similar petition was dismissed.
Where?
Annexure 4, Lordship.
Page. Page
Now, the page number 70 is the relevant part.
70.
70.
Yes.
Para number 8.2.
Hmm.
However, on perusal of the record, it appears that in the case in hand, admittedly, the power line was stringed in the year 2011 to 12, and the payment to the petitioner was made lastly on 2012. The instant case was filed by the petitioner on 26/5/2016. The petitioner contended that before coming to this court, he filed a representation before the opposite parties on 28/11/13, 14, 15, and 16. But the petitioner has miserably failed to produce those representations before this court for perusal. Besides, he did not make any effort to collect those documents from the authorities where he had submitted the same. There is no admission by the opposite parties about receipt of those documents. As such, it is crystal clear that the petition is barred by the law of limitation as provided in article. It should be 137, Lordship, 137 of the Indian Limitation Act. In the result, this issue is decided in negative and against the petitioner. On that ground, this petition was dismissed. And same facts, Lordship. It is regarding the same
What was
power
the
line.
what was the initial compensation as per the assessment made by the authorities? How much was the amount?
They have received, Lordship, he has received, Lordship, 14,710.
And what is the enhanced amount?
Enhanced amount is 20,941.
Only 6,000 difference. Why are you coming to the court?
No, Lordship, it is not relating to just one particular case. There are many PG cases.
And the other cases?
And the other case is the same, Lordship. Only the date of judgment is different. Otherwise, the facts are same, Lordship. I am providing a list, Lordship. I have given the judgment date. Also given a copy of the order passed by this honorable court, Lordship, which has stayed, the impugned judgment has stayed.
Item number 2, you don't know the enhanced rate.
No, that was not given, Lordship. In the judgment, it was not given, only at enhanced rate.
Third, MSM Devi, Learned Counsel for the petitioner, who by means of this petition has put to challenge a judgment dated 12/8/2022 passed by the learned additional district judge, Hailakandi in so and so, separate in so and so. The aforesaid judgment has been passed in exercise of powers under section 10, read with section 16, right?
Lordship.
Of the Indian Telegraph Act. Full stop. Amongst other grounds regarding the announcement made, the Learned Counsel has strenuously argued that the petition itself was barred by limitation, and therefore the same should have been rejected. Full stop. Attention of this court has been drawn to the specific contention raised in the written objection before the learned court below regarding limitation, which however has not been properly considered. Full stop. The Learned Counsel has also placed on record a similar case in which the learned judge had accepted the plea of limitation and had dismissed the petition. Issue notice returnable by 4 weeks. Yes, Mr. Go, you're for the state council.
Government 1 and 2, Lord.
1 and 2, huh?
TR Gogoi, Lord.
Mr. Go, TR Go for Government Council for response number 1 and 2. Let extra copies be served upon him within 2 days. Let notice be issued to the respondent, to the private respondents by registered post with AD. Put stop. Step within 2 days. Put stop. The Learned Counsel has prayed for an interim order. Put stop. This court, on perusal of the materials on record, is of the prima facie opinion that the objection regarding limitation has not been properly considered in the impugned judgment, and the claim and the said point appears to be a substantial point. In view of the above, till the returnable date, the impugned judgment dated passed by the Learned Additional District Judge Hailakandi in so and so available shall remain suspended. Over 4 weeks,
The item number 5, the date of judgment is different.
wait up the judgment.
Very much obliged.
Item Items are, you have mentioned the items here?
Yes.
Yes.
Look, petitioner has filed a proceeding under Land Grabbing Act, my lord. And the defendants appeared and they filed written statements. They have alleged their own case. And on the basis of written statement, they have prayed for issuing preliminary issues regarding maintainability of the proceeding. And my lord, the issues raised by the defendant request, my lord, evidence. But the landed court below, without going through the evidence, decide the matter against me.
Without going through the evidence or without adducing evidence?
Without any opportunity, my lord. Because as a preliminary point, it was dismissed, my lord.
Well, what was the point raised?
A point was res judicata. Res judicata always required, my lord, evidence. And second was that section 154 of Assam Land Revenue Regulation bars the civil court's jurisdiction. But as per the pleading of the defendant only, my lord, if they do not prove, my lord, how court can come to the proceeding. This system, my lord, notice maybe. Notice maybe.
Let us see the
Yeah.
impugned order.
Yes. Lord, impugned order
Which part?
starts from 52.
Which part?
Relevant portion starts from page 60, my lord. Page 60. Now, my lord.
But there were civil suits also earlier between the
Yes, my
parties.
lord, civil suit is there, but in the order itself, this civil suit, the parties are not similar, my lord. That is at page.
What is
63.
your name?
Page 63, my lord.
Gorigwala.
Gorigwala, my lord. And page 63, my lord. They are the parties' name are also.
But Dhanpal Gwala is your predecessor
Yes, Dhandal Gwala was
and
present.
it binds you. And it was against
But in that case, my lord, the other party was different, my lord. Kindly come to page 63, my lord.
Sahu difficult case. Okay, we'll issue notice at this. Third 3 S. Sahu learned counsel for the petitioner who by means of this petition has put to challenge. Why IO?
My lord, because appeal is there, but
No, why CRP IO? It is not against an interlocutory order. It's a final order.
no, my lord. Actually, I have preferred under 227, my lord.
Understood. It will be
227.
CRP. Why IO?
Because if I invoke jurisdiction 227, registry gives it as IO, my lord.
What is the meaning of an IO?
IO is against interlocutory order.
Is it an interlocutory order?
Interlocutory order.
Is your case an interlocutory order?
No, it is
Then
finally disposed of.
you have to point out to the registry. You have typed out as IO. Registry obviously will give as IO. Good. Go to challenge. An order dated. Now orders dated 8/5/2023. Why two orders?
My lord, by one order, he has framed the preliminary issues. And by the other,
Order dated 15/7/2023. Preliminary issue framing, how can it be a matter of adjudication or challenge? You're only aggrieved that final orders have been passed without the scope of adducing evidence. Seminar order 15/7/2023 passed by the learned special tribunal Sonitpur, Teshpur in special land grabbing case number 6 of 2019. Full stop. By the aforesaid order, comma, the application of the petitioner has been dismissed on a preliminary ground. Full stop. Para. It is the contention of the learned counsel that such dismissal could not have been done without adducing evidence from the parties, in which case the petitioners would have been in a position to cross-examine them. Full stop. Para. Issue notice returnable by 6 weeks. Let steps be taken for service of notice upon the respondent numbers 1 to 8. 1 to 8, is it? No, upon the respondent, there are two pro forma also.
All the
Upon the respondents, including the pro forma respondents, by registered post daily. Steps by Friday. Yes.
My lord,
Yes.
item 56.
Before taking up the matter, may I submit? Because I am this time appearing for the sole respondent. So this, if possible, matter be taken up at 2 or not tomorrow.
My
The
lord,
copy may be directed.
the problem is that, my lord, the learned, the principal judge, he has already fixed the case for judgment, my lord,
When?
on 24.
Tomorrow is what?
Tomorrow,
Without
tomorrow,
going for argument, he has fixed the case for.
We'll have
judgment.
it tomorrow.
tomorrow, Lordship. Tomorrow.
You give a copy to Mr. Bhuya.
Tomorrow.
I heard Sri J. Sharma, learned counsel for the petitioner. Full stop. Yes. Para. Sri R.K. Bhuya, learned counsel, however, has submitted that he has instructions to appear on behalf of the
So let's.
sole respondent and would be filing the power today. Full stop. Para. In the interest of justice, leave this case for motion again tomorrow. Full stop. In the meantime, let a set of the papers filed be furnished to Sri Bhuya. What has happened actually, Mr. Bhuya?
Lordship,
Some allegations, serious allegations have been made.
I do not know. I have to go through it, Lordship.
You were not there in the court.
No, I am not in that court.
This is a matter from which
And principal judge one,
family court?
family court.
Family court matter.
Yes,
How have you verified your allegations?
my lord, the indication is that first of all, he is giving very.
How have you verified? Let us see your affidavit.
Yes, my lord. And relevant portion is para 7. Para 7. That the matter has been proceeded regularly since 26/4/23. The Honorable Presiding Judge of Family Court, Mr. T. Kolita, has taken some biased decision and has fixed the date of the case with a very short date period and at instance of the respondent husband. The subsequent dates of the case are as follows. Various dates I have mentioned.
Yes.
Then, my lord, para 8.
Fixing short date, is it some bias action?
Then, my lord, para 8.
Yes,
8 is important, 8 and 9.
yes.
The petitioner begs to state that from the above, during the court proceeding, the learned presiding officer made some unnecessary comment against the petitioner which has no relevancy with the case. Once she told the petitioner that she has failed her duty as a wife. The petitioner is a private practitioner and for which she has to remain outstation for thrice in a week, which ought to have been considered by the learned presiding officer, but the learned presiding officer did not ready to hear anything from the petitioner when the adjournment was sought on 36 for cross of the DW as the petitioner was preoccupied by prior professional commitment. The PO has imposed heavy cost. Then the petitioner begs to state that on the last occasion, date was fixed on 14/7 for argument. But on that day, the learned presiding officer was on leave and fixed the case on the next day for 15/7. On 15/7, the petitioner could not present physically.
How have you verified, say,
due to her physical.
how have you verified the averments in paragraph 9?
Yes,
Has the council given an affidavit?
yes.
Where is the affidavit of the council? Let us see.
Council has not given that.
Then she was not there.
But my lord, they,
How can she know? You have made a statement on quotation.
yes,
Is she always in the habit of going outside? Ask your client to go to the Brahmaputra and wash hands
yes.
and come to the court with
That
clean hands.
statement he has made in the open court, my lord.
How have we verified this?
She was, the council was there. And
Has the
present-
council given an affidavit?
That can be filed, my lord. But
You are
but
making allegations against an officer, judicial officer.
that is true.
We are
my
not
lord.
saying that you are not entitled.
These
But if
are-
you make an allegation, you have to face the consequence.
Yes.
You put it properly on record, we'll take action as per law. Otherwise, don't make stray allegations like this.
But then, my lord, the case has
I
to.
verify it with an affidavit. She was not there.
We'll
How does
file-
she know?
We'll file the additional affidavit.
File an additional affidavit.
Yes, my lord.
And this may not be the seriousness which you have expressed. This may not be because it speaks for judgment. We are not expressing anything now. We'll hear you tomorrow.
My lord,
but we have serious doubts.
Without even argument.
It appears to be foreclosing or preempting something, a court from passing a judgment. You should have come earlier if you are seeking, if you are sensing or perceiving a bias in the court. Just one day prior to the judgment, you come to the High Court and say that judgment is going against me, so pass an order. We are not going to.
That is at least some.
Tomorrow,
chance should be given for argument.
tomorrow we'll hear it.
And we'll
Mr.
file-
Mayor. And file the affidavit.
My lord, we'll-
Allegations against judicial officer without a proper affidavit, we may impose heavy cost upon him.
Yes.
Yes. Saying, what is this?
My lord, decree has been passed by the trial court. It was upheld by the first appellate court, upheld by the Honorable High Court in the second appeal. And when the decree was put into execution, the decree holder made an application behind the back of the judgment data that the dag and patta is erroneous, it needs to be changed. The executing court changed it. And now they are pushing to execute it on a dag and patta, which was not the subject matter of the suit. My lord, kindly see,
Who are you?
I am a third party, my lord. But
Now by the change in the Dagan Patta, you are being affected.
yes, my lord.
Yes,
And
yes, Mrs. Sahu.
we don't-
Can an executing court go behind the decree and make corrections?
No, that amendment proceeding is there, my lord. That power is there.
Amendment by which court?
By executive court itself, my lord.
Where is your application? Let us see. Where is the power?
My
Your,
lord,
where is the power?
my lord, power is given by the Honorable Supreme Court, this Honorable Court itself. my lord.
No, power by the code. We are not by the court. We power by the code, CVC, CPC.
A court.
Yes.
Oh, there is nothing, my lord. Judicial.
You are depending on an interpretation.
Judicial.
You're depending on an interpretation.
What happened?
Hmm. Now, what is the stage now?
Now it stays, my lord, at the executing stage, my lord.
No, it's
They
come
have
up
they
for
have
it.
got the stay of my execution proceeding, my lord.
Yes.
Earlier, the suit dag was dag number 633,
See what Mr. Singh has said,
my lord,
that there was a decree.
my lord.
It was affirmed by even in the second appeal by this court.
Yes,
Till that time, you did not even think that there was any change required.
yes.
When did you go for an amendment of the?
At the executing court, my lord, at the stage of executing court.
Under what provisions?
Direct provisions are not there, my lord.
Then
But, my lord, so many decisions are
let
there.
us see one decision.
Yes, my lord.
Now we can hear this otherwise.
My lord, may I show something?
No, not today. We can hear this. No, if he has got something to show,
My lord,
since this matter is of
My lord.
2022.
I will only take 5 minutes, my lord. Everything is clear. Just give me 5 minutes, my lord.
No, if you are arguing for a disposal, we'll grant
Yes.
this time.
Yes, my lord. Stay is there already, my lord. It will.
We'll continue to stay and fix a hearing on a hearing date for admission hearing. What is this? Decree. Sorry, the decree of redemption of mortgage.
It was hard actually, my lord, by other banks. kept for
Just a minute, just a minute. Here the warrant of possession was wrongly issued. It was not as per decree. You cannot change a decree by an executing court.
Milord,
What is this absurd
Milord,
proposition of law?
wrong quotation, Milord, that Madras High Court judgment is.
It's not a court of question of wrong quotation.
Milord, omission, Milord, this one. In this Milord, in the plain, the property was wrongly described, Milord. In that case, so Honorable Supreme Court has allowed, Milord.
Which paragraph?
Milord.
Is it the stage of the trial itself?
No, Milord.
The trial court,
Executing court, Milord.
where?
Milord, paragraph 8 speaks about decree, Milord.
Come to paragraph 15.
Yes. That speech is applied here, Milord.
Where? Which paragraph?
Milord, paragraph 8 speaks about decree. What was the decree, Milord?
Yes.
Thereafter, Milord, paragraph 16, Milord.
No, he is a third party. Now he is being affected.
Milord.
Can he be affected?
Yeah, then he has to show his independent right, Milord. He has to show his independent right,
He was not even a party.
Milord.
He was not even a
Now he has to show that I have a right over the plot of land. First of all. Secondly, the land is not his. What is his contention, Milord? That contention is.
You are inviting him to the court. Why should he show? First, it is the onus is upon you. You discharge your burden, then the onus will shift upon him. How can you put the entire onus burden upon him?
He is a third party, Milord.
Yes.
He has applied for the application under order 21, rule 97, Milord.
Yes.
So he has to show that he has an independent right over the land, Milord.
Give me that opportunity, my lord, in that.
See, Rule 97 is only for the purpose that you did not file a separate suit. That is the only objective. There is nothing else. Only to
Yes.
avoid multiplicity
In
of
case of
suit,
suit,
he can take
That
the course of
proceeding he can
2197.
yes, Milord. That in that proceeding, he has to show his independent right, Milord. No independent right he could
But
show.
will the executing court has that power to change? Now, if the executing court had proceeded and with the same Dagnapa Patta number
Milord.
was infringing his right, then he comes up to the court. Now, here is a case where the description of the land has changed.
That has been changed into resettlement, Milord.
My lord, the doctrine of merger says that once the trial court's judgment gets merged with the appellate court's judgment, the appellate court's judgment merged with the high court's judgment. Now, if there is any application for any sort of changes, it has to be made before the honorable high courts. Otherwise, the doctrine of merger will be wiped out. But that has been done by the learned trial executing court. And when I approached, the learned trial court's executing court says that I cannot go beyond the decree. Now, already they have traveled beyond the decree. Somehow,
Where is that order?
my lord. First of all, my lord, can you see page 16? Page 16, my lord. That is
16.
annexure 1.
16.
16, that is annexure 1, copy of the plan, my lord, the only to show the schedule of the land, my lord, page 16.
Yes.
Kindly come to the bottom portion, my lord,
Yes.
schedule.
Hmm.
The
That's
card number
633.
633 and patta number is 9.
Yes.
And there is 4 boundaries, my lord, within which this has to be executed. Now kindly see the annexer, my lord, 3, 4, and 5. These are the judgments of the learned trial court.
Page.
My lord. Kindly come
Now
to
let us come to the impugned order. Let us see the impugned order. It will
Yes,
be clear.
my lord.
Is it
Now what-
page 80, 78,
It is page 75, my lord.
75, yes.
Kindly see annexer 14, my lord.
Hmm.
Para 4.
Hmm.
Petitioner has contended that DAG number 633, Patta number 9 is a government land. And
Hmm.
land bearing DAG number 634 and Patta number 6 stands in the name of the brothers of the petitioner and is not yet partitioned.
Hmm.
So DAG number 633 is a government land, my
Hmm.
lord. Perusal of the case record reveals that white order dated 14th of August
This
2018,
petition is by whom?
my lord, by the
The
decree,
decree holder.
this application, my lord,
Yes, by the decree holder.
my lord.
Who is Suran Sikya?
No, it is by me. It is by me. It is by me, my lord.
Okay.
This is the impugned order, my lord.
Okay.
Perusal of the case record reveals that
Mr.
the
Sahu,
white-
you are Punjabi Hari.
I'm Punjabi.
Yes,
And now he's AR5.
Yes,
So it doesn't matter. Okay.
Perusal of the case record reveals that while order dated 14th of August 2018, it has been observed and held by this court that DAG number 633 and Patta number 9 of the suit land mentioned in original decree passed its title suit number 195 had changed to Patta number 6 and DAG number 634. As per the settlement record of 1987, I pause for a moment, my lord. The suit was filed in 1995 and the entire changes, if it has taken place prior in 1987. And court further directed issuance of fresh writ with respect to altered Patta number and DAG number of the suit land for proper execution of the decree passed in title suit number 195. Further, the contention of the petitioner that the other brothers of the judgment debtor have not been impleaded in title suit number 195 has already been decided in the judgment of the instant title suit. And then as an executing court, it is beyond the purview of this court to go beyond the decree in title suit number 195. With this observation, my lord, the application of mine was rejected. Now kindly see, my lord, the interesting part. Come to page annexer 10, my lord.
Page
Page 65, my lord.
65.
65, annexer 10.
Yes.
Para 3, on perusal of the same, I have observed that this instant execution case was based upon decree passed in
Para
title
3 on, yes.
195 to evict the JD with his main and materials and construction of the recovery of the first possession of the scheduled land, and also by restraining the JD permanently from entering into the suit land after eviction, and for recovery of the cost of the suit from the JD by attaching and
This is
selling
not
his-
first position, this is first position.
Third, learned counsel appearing verbally submits that DAG number and Patta number of the scheduled land has been changed. And in this regard, DH side has examined junior assistant RKG branch, DC office Tejpur, Subrata Lodh and Parag Bora and Lat Mandal of Tejpur Revenue Circle as court witness, and also produced the certified copy of present Jamabandi in this regard. On clear scrutiny, as testimonies deposed by junior assistant RKG, Subrata Lodh and Parag Bora Lat Mandal of Tejpur Revenue Circle, it is clearly apparent that Patta number 9 and DAG number 633 turned to Patta number 6 and DAG number 634 as per the settlement record of 1987. And at present, copy of Jamabandi Patta number 6, old 9 and DAG number 634, Patta number 633, as mentioned, it is further stated by them at present DAG number 633 remains as government land, and DAG land belongs to DAG number 633 and 634 are different lands. Now, my lord, if these are two different lands, and if the entire decree relates to DAG number 633, how can it be now executed in regard to DAG number 634? That is why I am submitting, my lord, the doctrine of merger has to be wiped out. Now kindly see, my lord, the Jamabandi that was produced before the learned trial court, it clearly shows, my lord, that this DAG has existed since 1987.
Mr. Singh will have this later. We'll extend the interim order. Suggest a date of your convenience.
Can it be kept as part third?
No, not part. We'll not have it immediately. There is no urgent. Origin seizure. Tell us the date.
On 30th of August, my lord, 30.
Not 30, not on Wednesday. We can have it on
On 1st September, if it is Tuesday.
1st September is a Friday. We'll have it on 7th of September.
Below
7th September,
7th September.
Thursday. Heard.
No problem.
Sri S.K. Singh, Senior Counsel, assisted by Sri B. Pushila for the petitioner, whereas Sri S. Lahu has appeared for all the respondents. All the respondents. Full stop. The parties are in agreement that the matter can be finally disposed of at the admission stage itself. Full stop. Para. List for admission hearing on 7th of September, 2023. Full stop. Para. Interim order passed earlier to continue till the next date of the
Highly obliged.
Obliged.
You take this, you will need better decisions. This will not help you. Eight.
Well, this is a how filed against the injunction order granted by the Learned Trial Court Lordship. Fact of the case is this, Lordship, that the respondent, one, he was the owner of a plot of land measuring 2 bighas.
You are a defendant in this suit.
I am the defendant. And the plaintiff lot, the respondent plaintiff appointed the respondent number 1 Lordship as the power of attorney.
You are the power of attorney.
No, I am the purchaser.
You are the defendant.
I am the defendant number 2 and 3.
2 and 3. What has happened?
Then Lordship, the plaintiff obtained the sale permission from the DC Amingram, and thereafter the sale deed was executed through the attorney Lord, and full consideration amount was paid. Thereafter, Lordship, the respondent, that is the plaintiff, started to blackmail that you give me more money, otherwise I will file a case, and to which I refused. Ultimately,
But the sale deed was executed.
yes, sale deed was executed. Entire consideration amount of 50 lakhs was paid by check on paid check. I have annexed all the documents. Thereafter, Lordship, just to blackmail the plaintiff, respondent plaintiff filed the suit for declaration of right title interest, cancellation of
Sale deed.
the sale deed, Lord. I appeared, filed my show cause against the WS as well as the show cause against the injunction petition. After hearing the both parties, Lordship, the Learned Trial Court passed the impugn order directing both the parties to maintain the status
In the injunction petition.
in the injunction petition and not to encumber and to maintain this and not to do any construction over this. Here, Lordship, the entire pleaded case of the plaintiff is based on falsehood law. And I have taken this plea. Not only that, in the plaint, Lordship, the plaintiff has stated.
You are in possession, aren't you?
Yes, I am having my houses, Lordship. I constructed 4-side boundary walls. I developed the approach road by putting 5 numbers of home
The
pipe.
suit was instituted in which year?
Lordship,
Suit was instituted in which year?
see, 23.
23.
Yes.
What is the stage? Same
Stage
stage.
is I have filed the WS, then the next date is for framing of the issue.
We want vacation of the status quo order.
At least I am ready to give undertaking that I will not encumber anything, but only I may be allowed to develop the land, further development. Because Lordship, in the plaint, Lordship, the plaintiff has stated that she never knew the purchaser and she never met. But see, Lordship, I have annexed the photographs. I am also having the videography.
When is the next date fixed?
Next day.
We'll do one thing, Mr. Roy. We'll fix a date after the next date. In the meantime, we inform the council. We'll try to pass some orders in the presence of the council. That will be the best course.
But council is from Mingaon Port.
Doesn't matter. They can have somebody else here.
I may be allowed to take steps by registered court.
That is also okay. Yes. But we don't want to admit this at this moment. Let it come up for admission itself.
Okay.
We'll pass a formal order that you can inform the council on the next date, and we'll fix it. Just ask your junior to have the date. Okay. I heard 3 SP Roy Leonard Council for the appellant who has preferred this appeal against and order dated 22/5/2023, by which the parties to the suit are directed to maintain status quo with regard to the suit land till the disposal of the suit. Full stop. It is the case of the petitioner, it is case of the appellant, that the suit was instituted by the plaintiff for right, title, and interest, and for and also challenging a sale deed by means of which the suit land has been alleged to be purchased by the present appellants who had the defendant numbers 2 and 3. Full stop. It is further contended that the sale deed was duly executed and the plaintiff was represented by a power of attorney, and the entire suit has been instituted with mischievous intention. Full stop. Para. This court is of the opinion that before admission of this case, before admitting this case, it would be just and proper if the contesting respondent, who is the plaintiff, be granted an opportunity. This court has been informed that the next date before the learned trial court is fixed on.
I will get it.
So and so date. Full stop. On the said date, Sri Roy, the learned counsel for the appellant, undertakes to inform the learned counsel for the plaintiff and also apprise about the next date fixed in this by this court. Full stop. Para. List on so and so date. We'll fix the date. Collect the date later. First, you give the date. We'll fix the date about around 10 days from the date.
Right.
You also try to furnish a copy to the learned counsel. List on the date for admission. Yes.
Your Lordship, one line I may be allowed to serve by dusty service to the learned counsel for the plaintiff.
We are not issuing notice at this stage. That will not be proper. You informally serve him. Yes.
Please, Your Lordship. Lordship, we have filed this appeal amongst other grounds that there is violation of policy condition, Lordship. The driver was driving the vehicle.
It's within time.
Lordship, yes, Lordship, it's within time.
That case. That case.
That case, Lordship.
How much is the amount?
The amount is, Lordship, 11,58,000.
What was the deceased doing?
Lordship,
What was the deceased doing?
he was working, Lordship, he was working in the office of the owner, Lordship, in Creative Consultant and Builders, Lordship. It happened in the premises of the office of the Creative Consultant and Builders, Lordship.
This is a workman compensation or MSc appeal? MSc appeal.
His MSc appeal. Lordship, he is not the driver. He was working in the office what happened was, Lordship, the Tata tipper, it went and hit the wall of the office of the creative consultant, and the deceased was working in the office at that time.
He was working at Manipur.
Yes, Lordship.
Heard MSc Mazumdar, Learned Counsel for the appellant, who has preferred this appeal against a judgment dated 29/3/2023, passed by the learned MACT Nagaon in MSc case number 22, by the impugned judgment, an amount of rupees 11,58,000 has been awarded to the claimants who are the legal heirs of the deceased. What are your grounds?
Lordship, this violation of policy condition because the driver was driving the vehicle having an LMB license.
The learned counsel has alleged that there was violation of the policy conditions, and therefore the insurance company should not be saddled with the liability. Admit call for the LCR. Less steps be taken for service of notice upon the respondents by registered post, by usual process, as well as by registered post with TD. Steps by Friday.
Lordship.
You have an interim prayer.
Lordship.
You have an IA.
Yes, Lordship. We have filed an
Or,
IA. 19.
MSc Mazumdar Learned Counsel for the appellant who has filed this application for stay of the judgment dated or passed by so-and-so in the learned counsel has submitted that there are good grounds in the appeal. However, considering that the award has been passed in a death case, this court is not inclined to pass a blanket order of stay. Accordingly, a conditional order of stay is passed directing stay of the impugned judgment and order so-and-so, subject to payment of 50% of the amount before the registry of this court, which will be done within a period of 2 months from today.
Much obliged, Lordship.
Affidavit affidavit. It called for an affidavit.
Yes, my lord.
Has it come? I don't
It
think.
hasn't come, but I have an extra copy, my lord.
Anything? Any discussion?
No, my lord, discussion has happened. Now, actually, my lord, we are making.
You should have
construction-
presided over the discussion. Both of you rather.
No, my lord, I think there is a necessity of further negotiation. What had happened? Actually, we are making construction in our own land.
That is your case.
The land which belongs to him pursuant to that partition, my
Partition.
lord. There, the elder brother is having that office of the gas agency. Now, what had happened in the paternal building, my lord, the second floor belongs to the elder brother, Ashok. Now, what my learned friend's client has done, he has illegally occupied that.
Second.
Yes, otherwise he says, where do I go take my gas's office? I have to take there. That has to be thrashed out. Otherwise, there is no problem, my lord. Otherwise, everything is clear.
There is no dispute in ancestral plot of land.
There is,
In
there
this-
is a
there is no
partition.
dispute.
No, that's why I say,
This is independent, which is passage land mine. So this has to be defined.
if that
decided
is his
separately.
case, I'll satisfy your lordships, he has no case, my lord. If I thought, my lord, since it's a matter between the brother, I'll not go legally. I thought.
Why
let
don't you
them
sit for
settle their
mediation?
matters.
No, I'm open.
If
for
my
it.
learned friend is taking a legalistic
I'm-
view,
I'm open to
I'll
it.
submit.
No, will not allow him to take a legalistic view.
My lord,
At this point, we'll not allow you to take a legalistic view.
Well, I am
Sit
not
for
making-
mediation
therefore,
first,
yes, no
then
case
we'll
laid
come
out
to the
for-
court.
My lord, there may be a lot of differences in heart, my lord, in mind somewhere, my lord, not on records, my lord. This is independent of that, my lord. And for that also, my lord, the ancestral plot of land also.
See, both of you are,
It is.
both of you are agreeable for a mediation. Let it go for mediation. You try and,
Another motion
My lord.
for 2.9.
huh?
No, my lord, I am appearing for response number 2.
Who is to?
Response number
The
two is
builder.
No. Response number 3 is the builder. Response
elder
number
brother.
2 is the elder brother.
Elder also.
Now, let me just make one clarification. Now, they are saying that the office which I am operating locate is from 1974. And the partition which took place within 3 of us, that is in 2020. Kindly see. Now, in that partition, 3 of us, we participated before the circle officer. We agreed mutually that 2.99 Rs will go to the petitioner, the appellant, and 5.99 Rs will come to both of us. Now, that office is just in the side of, I have got photography evidence to prove that. That office is just near that place where the construction is going on. And the office is full of land. And what my learned senior is saying, that flat, which has been illegally occupied, their lordship will kindly see, in the first floor, the mother, the old mother, she is staying, she is sick. And they are creating all motion by operating that particular flat. We have been requesting him, vacate it, no. But anyway, so if mediation takes effect, the mediation may kindly take into effect all the litigations that are going.
Exactly.
That is the purpose of mediation. We are not confined to a particular
Otherwise,
litigation.
had it been to this case, it would have been easy, my lord. We are not making
Mediation,
construction
we are
over
not
his land.
even seeing the records. We are not even seeing him framing any issues. Parties are there to trash out everything, all
My lord,
differences,
My lord,
once and for all.
my lord, we are open to discussion or a settlement on this land. We are open to discussion on ancestral land. I am making myself clear, my lord. But let them not mix up the matters, man. There is a purchase land and that is that, my lord. Because unless they understand
See, by
this issue,
taking
my
the-
lord, unless they understand this issue, my lord, it will not be fruitful.
Now, by taking the clue of this particular case, trash out all your difference.
They are present, my lord, they are trying to blackmail us, my lord. So they, with force, they have occupied my land. And now they are trying to negotiate.
No, you are going for a mediation. Now you have to go with a clear, open mind.
Exactly that, my lord. That's what I want.
Let's we lawyer not enter into this, my lord. Let brothers face out.
Yes.
In between, my lord, the interest of the builder has come up, my lord. My senior friend is representing my lord. That is,
You're for the builder.
I am for the 1 and 3, my lord. Yes. Builder and one of the brother.
builder is also represented by one of the brothers.
They may have the same point interest.
Please, we should not mix it up. No. Lordship may
My
kindly
lord,
see.
my lord, let us not do
So
our
we're not going
equality in
to-
this case, my
No,
lord.
no.
I can do my equality very well, but I'm not doing it.
Yes.
A separate wakalat numbers are there, my lord. It's not that.
Heard Sri B.D. Goswami Council for the appellant, whereas the respondent numbers 1 and 3 are represented by Sri K. N. Chaudhary and Senior Council, assisted by R. Kakoti. Full stop. Sri Mr. Bhattacharya for?
I have for response.
No.
I have for response.
A. Bhattacharya for respondent number 2. Ms. Malakar with you? Is it you? Mr. Bhattacharya, K. Malakar.
Malaka is with me.
Yes, okay. And you, Mr. Bhattacharya for?
5 and 6.
Four. Okay. And Sri Bhattacharya for these state council for respondent number 5 and 6. But I think 5, 6 presence may not be required in the mediation.
No.
No.
Para. Though this court has noticed that though in this appeal, respondent number certain state entities have been made respondents, comma. this, in view of the order proposed to be passed today, comma, the same may not be effective, may not be applicable to the said respondents 5, 6 and 7. 5 and 6, 5 and 6. What the para? The dispute is amongst the members of the same family and the appellants, comma, respondables 2 and 3 are brothers.
1 and 2 are the brothers.
No,
One and two, my lord.
not 3. The appellants and the respondables 1 and 2 are brothers.
1 and 2.
And it is on record that a partition has already been effected between the parties. The allegation in the suit is that some constructions has been done on the share of
No,
the
my lord,
appellant.
without partition, that's the thing.
No,
The
on the share
allegation
of-
is Without partition, that's a wrong statement.
The allegation in the suit is that without there being any partition, comma, construction is being done on certain part which would come within the share of the appellant.
Though that is not a fact. That's the allegation.
The aforesaid allegation, however, is disputed
Yes.
by the contesting parties. This court is of the opinion that taking into account the nature of the dispute and the parties involved, comma, an attempt be made to resolve the dispute between the parties by way of a mediation. As proposed and agreed by the parties, comma, this court appoints whom? Mr. Bhatra is there.
Yes,
RK
my lord, yes,
Bhatra.
my lord.
RK Bhatra.
Yes, yes. We have no objection.
I don't think he's got any interest. Bhatra.
Yes,
RK Bhatra, I think
yes,
is a
yes.
trained mediator. Appoints. Junior Bhatra is there.
Yes, my lord.
Inform Senior Bhatra. Nowadays, we have a lot of advantages
In communication.
in communicating. Are you in dispute with your senior like this? No. No litigation. So communicate. RK Bhatra, a trained mediator, to act as the mediator. Full stop.
My lord, we can appear on next Monday to expedite.
Let the papers connected to this case, let a set of documents and papers connected to this case be handed over to the appointed mediator within a period of a week, whereafter the mediator, learned mediator, may fix a date within a week thereafter. Let this matter be listed on today, 17th, on 25th of August, by which date a preliminary report may be furnished by the learned mediator, apprising the progress, whereafter this court would pass necessary further orders.
My lord, till then, my lord, they will make this status quo with regard to the order.
My lord, we are making construction about our own land, my lord. The bone of contention
That is
is,
dispute.
yes, that part
That is
of
why
the portion of
injunction
his
was
land,
for, my lord.
no, the part of
Since
the
we have
portion
come
of
for
his land.
negotiation, my lord, your lordship has said.
I think you just restrain for some time.
Okay, my lord, we'll not
Let
go
the
ahead.
first sitting.
Okay,
Let the
we'll
first
not go
sitting.
ahead.
Let the first sitting.
Till 25th of August, we'll
Don't
not
do
go ahead.
anything. Don't do- Because
Let there be an observation.
Let
to
go
that
by
effect,
hand.
my lord. Let there be an observation.
we're not making a Sri Ken Chaudhary, London Senior Counsel, as well as Sri A. Bhattacharya, London Counsel for the Respondent number 2, has undertaken that till the next date, comma, there will be no change caused to the property in question.
Yes.
Yes, my
Deep-
That's all.
Six zero. Dekha,
May I please, my lord?
Yes.
In this case, I need some time to obtain instruction.
you're for the CGC,
Yes, my lord. This is-
madam?
Lordship, simple case, Lordship, for modification of judgment and order dated 27 February, Lordship. Whereby tribunal has awarded rupees 8 lakhs as compensation, Lordship.
In a WC case, what case?
Lordship,
Railway can claim for
yes,
what?
yes, Lordship,
Railway.
railway claim tribunal. As compensation, rupees 8 lakhs, Lordship, divided into two parts for mother and father. 4 lakhs, Lordship, with interest. But the amount, only 50,000 will be released, Lordship. 3 lakhs 50,000, Lordship, automatically fixed.
Has been made fixed deposit.
Yes,
And
Lordship.
it is already reflected in the order passed by the railway tribunal. So, my lord, I need some time.
What,
obtain
no,
instruction.
no, what is your difficulty? Let us see.
Lordship, only 50,000.
Let us see the judgment.
No, my lord, there is another aspect, my lord, I would like to point out.
No, no, we'll hear you. Because she's not praying for any enhancement as such.
Yes.
She's only on the,
Pray for any.
she's only praying for the division, isn't
Yes,
it?
Lordship.
Yes, my lord.
Where, what is it?
Lordship,
Page,
Lordship, page number 23.
there is already a modification similar by this
Yes,
court.
Lordship, yes, Lordship.
It is
Lordship already modified.
Page 20.
Page 23,
23.
column A, Lordship, the compensation amount of rupees 4 lakhs is payable to the father of the deceased, namely Akhtar Ali.
Column, 23 column.
Page number 23,
Yes,
para A.
para
Column
A.
A,
Oh, yes, yes.
Yes,
Compensation.
rupees 4 lakhs, Lordship.
Hmm.
Rupees 4 lakhs is payable to the father of the deceased, namely Akhtar Ali. Rupees 50,000 along with the interest of this amount will be payable to him through NEFT transfer, and the rest of the amount of 3 lakhs 50,000 will be kept as fixed deposit, Lordship,
Hmm.
in a nationalized bank for 3 years, Lordship.
Hmm.
On completion of 3 years, the entire amount along.
Similar for the mother also.
Yes, Lordship, similar.
Now, what is the change you are taking?
Lordship, only mother and father, Lordship.
Now, what-
Unmarried, he was unmarried son. This person was unmarried.
And what are you seeking in this appeal?
Yes, Lordship.
What is your prayer in this appeal? What?
Lordship, my prayer is, if 2 lakhs will be fixed, I have no problem, Lordship. I have no objection, but the only 50,000 will be released. How can survive? The other was the 66%, 66
Yes, yes.
years old.
What is your problem?
No, my lord, I do not have any problem, but the thing is that, my lord, this case has been looked after by a buyer. And today she is out of session.
Doesn't matter. We'll record your name. It's the only a modification, and there is already an order. The prayer is absolutely reasonable. Out of 8 lakhs, is only 1 lakh is paid at this time. What is the moment objective of paying a compensation?
Yes, my lord, let 50% be released right at this moment, and the rest 50,000 may be made.
No, we'll make it 50%. Yes, 2 lakhs to be released and 2 lakhs to be kept in FD.
Yes.
No, to that extent.
Yes, yes.
With interest.
Modify.
Will be
Yes,
released.
your J. Kolita
Yes, Lordship.
heard MSJ Kolita, learned counsel for the appellant, also heard Sri B. Dekha, learned CGC. Full stop. By the present appeal, comma. No, the present appeal has been filed on a very limited issue. Full stop. The appellants have lost their son
Yes, Lordship.
in a railway accident, whereafter a claim was lodged before the learned railway claims tribunal. Guwahati bench, which was registered as claim application number, aesthetic, yeah, यहाँ पे page 12, OA aesthetic reflector. On 3/6/2019, full stop. The learned tribunal by judgment dated 27/2/2023 had directed payment of rupees 8 lakh in total to the two claimants within bracket appellants, to the two appellants within bracket claimants by dividing the same equally. Full stop. However, in the operative portion, comma, the learned tribunal has directed that out of the amount of rupees 4 lakhs which were payable individually to the two appellants, comma, only 50,000, only an amount of rupees 50,000 with interest was to be transferred, was to be released, and the rest amount of rupees 3,50,000 each was to be kept as fixed deposit in a nationalized bank for 3 years, whereafter the amount would be transferred to a savings bank account. Full stop. Para. The learned counsel for the appellants submit that the aforesaid observation regarding fixation of the installment, regarding fixation of the installment is not reasonable and would be against the objective of payment of compensation in a claim in the Railway Claims Tribunal. Para. The learned counsel has also relied upon a similar order passed by this court dated 10/3/2023 in MFA 33 of 2022, wherein similar an order of similar nature was modified to the extent that rupees 2 lakhs was directed to be deposited. To the extent that out of rupees 8 lakh, comma, an amount of rupees 2 lakh was modified. Para. Sri Deka, the learned CGC, submits that he would not object in principle as the appeal is not for enhancement and only only in connection with the manner of release of the amount. After hearing the parties and on perusal of the materials on record, comma, the instant appeal is allowed by modifying the impugned judgment dated so and so, passed by the Railway Claims Tribunal so and so, by directing that for the present, comma, both the appellants would be for the present, comma, for the present, comma, an amount of rupees 2 lakh each shall be released to both the appellants, and the remaining amount along with interest be deposited and be kept as fixed deposit in a nationalized bank for 3 years, whereafter the matured amount may be transferred to the savings bank account of the appellants.
Lordship, kindly Lordship, with interest.
No, for 2 lakhs. Out of 4 lakhs, you are being given 2 lakhs. That is okay. That the interest accrue. With the aforesaid modification, comma, the appeal stands disposed of.
Okay.
Mr. Mohanta, anyone? Elementary? Mr. Bhattacharya, I informed some.
My lord, I had informed them. But they may do one thing. Today is good.
Wednesday.
Tomorrow or day after, what they may fix it.
No, why aren't they here? This matter
They
is
should- They should.
assigned to this bench.
That is why, and it has been also notified in the cause list.
We don't want a senior counsel to be remain seated like this.
They are,
It's the number of item number 1, none is present till now.
it's difficult, my lord. My lord, may confute to your lordship. The cases in that way, all being taken time and all, we come rushing to do the cases, but in fact, practically nothing happens. Goes
No,
on
but-
and on and on.
That practice will not continue. You come at 2 o'clock.
Yes. Lordship will take up finally, let the message go to them. Oblige.
My lord, this is a bail application. My lord, the fact is on 27/11/2021. The special information was shared by the BSF that huge quantity of narcotic drugs at village East Balia Karimganj in the house of Samsul Noor is suspected to be there. Accordingly, my lord, police went there and they found the material and Samsul Noor was arrested from there.
What is
Now-
your name?
My name is Anjan Nath. Now, during the course of investigation, my lord, petitioner had confessed that he used to smuggle foreign cigarettes and supari, there is barbis. That is the whole confession given by him. And my lord, police, in terms of section 52 of the act, my lord, they are to give certain grounds of arrest, and they have given the ground of arrest, specifically stating that only. Now, the co-accused, one co-accused is Philip Day. They were doing that business, and the new ground is, my lord, the Philip Day has been enlarged on bail only on that count. My lord, I will take your lordships to that. My lord, the ground of arrest first, which your lordship will find at page is 20, my lord.
20.
20. My lord, your lordship may come the bottom ground of arrest. Found sufficient evidence against him. He confessed his guilt. He is a drug dealer. Found sufficient mobile phone linkage with other drug peddlers as per CDR report. I therefore pray your honor not to release the accused person on bail at the stage of investigation. The cause of arrest is duly communicated. Now, your lordship may turn to page 24. Your lordship may see ground of arrest here. During has your lordship got that? Page 24. ma'am.
Yes.
Ground of arrest. During investigation, remanded accused Anjan Nath, there is a petitioner, confessed his guilt, and he also stated that his co-accused Philip Kumar De is involved and they smuggling drug like cigarettes, betel nut permit since long time in various places, and they transport the same from Champi with Forum, and they also communicated over mobile phone doing drug smuggling transaction and accused is veteran smuggler in drug related items. As per CDR analysis, it found that both Anjan Nath and Philip Kumar De conversation each other in so many times, which maybe, your lordship kindly see the word maybe, drug related conversation. During search, I recovered 4 cartons, total 19 packets foreign cigarettes from Philip hidden house. So it is clear Philip is veteran smuggler. Also, he associated with Anjan Nath. Now, your lordship may see the bail granted to Mr. Philip. Your lordship will find that at page my lord, '46. Order dated 3/5/2023. Heard Mr. So and so. By this petition under section 439 CRPC, accused petition namely Philip Kumar De has prayed for grant of bail in connection with special NDPS case number so and so. Scanned copy of the case record along with the case diary is called for is placed before the court. Mr. So and so for the accused petitioner submits that the accused has been in judicial custody for more than 1 year since 23/3/2022. Although during house search, only 90 packets of Korean cigarettes were seized, and this led to an assumption that he was an associate of co-accused one Anjan Nath. Drawing attention to the grounds of arrest contained in the forwarding report, Mr. So-and-so submits that co-accused in his statement disclosed that the present accused and he were trafficking drug-like cigarettes, betel nuts, barmi, since long from Mizoram. So-and-so therefore submits that the accused petitioner ought not to have been booked under the NDPS Act. Opposing the bail application, Mr. Goswami, learned additional PP, submits that the case diary reveals that the learned trial court is yet to consider the charges against the accused petitioner. And the case diary reveals that the accused was constantly in contact with the prime accused Anjan Nath in drug trafficking. Therefore, Mr. Goswami submits that in view of the bar under section 37 of the NDPS Act, the bail application may be dismissed. The case relates to recovery and seizure of 24.155 kg of Kiowa tablets from the house of accused Abdul Bashid and Samsul Noor. The seized tablets contain methamphetamine. It is noted that the accused petitioner is in judicial custody for 406 days since 23/3/2022. A perusal of the case record reveals that the police, after completion of investigation, did a charge sheet under section so and so against the present accused and 2 others by order dated so and so. The charges are yet to be considered by the learned trial court. The FSL report shows that the sample of these tablets gave positive test for the so and so. On reading of the statement recorded under section 161 CRPC available on the case diary, it is prima facie revealed that it deals in export and import of Burmese shupari and foreign cigarettes in association with Anjan Nath and others. 90 packets of cigarettes were recovered from his house. The investigation is completed with the filing of the charge sheet against whom is permanent resident under the Silchar PS. Therefore, this court is the opinion that the restriction of section 37 of the NDPS Act may not come against him, and accordingly his further continuation of detention for the purpose of trial may not be warranted. In the premises, now these are the conditions given for bail. Now, my lord, in earlier occasion, which
Why the restriction would not be applicable?
my lord, your lordship kindly see. The
37 is the only provision under the NDPS
yes,
Act.
your lordship is very correct, but why it's not applicable here? Your lordship will first see the recovery of what from Mr. Anjan Nath, only mobile, nothing else. And if you want to connect with the 24.155 of these
Tablets.
drug under the Act, if it is said to be narcotic drugs.
Will come.
Well,
That's fine.
but here, main accused Samsun Noor from the huge quantity of narcotic drugs have been recovered. He was enlarged on bail long back. And the 3 absconder, they have been also granted bail. Now, His Lordship has asked me the question that why 37 is not applicable. I'll take your Lordship first section 41 of the Act.
Okay. NDPS Act. NDPS Act. Get us narcotic drug. Yes, please. Thank you.
Section 41.
Yes.
At page 31, you know. This is a procedure, my lord.
Hmm.
Power to issue warrant and authorization.
Hmm.
A metropolitan magistrate or a magistrate of the first class or any magistrate of the second class specially empowered by the state government in this behalf
Hmm.
may issue a warrant for the arrest of any person whom he has reason to believe have committed any offense punishable under this act. Now it will have to be under this act, you know. If it is under this act, then section 37 will be applicable. Now I'll take your lordship to section 37. Offenses to be cognizable and non-bailable.
Mhm.
Notwithstanding anything contained in the Code of Criminal Procedure, every offense punishable under this act
Mm.
shall be cognizable. No person accused of an offense punishable for offenses under section 19 or section 24 or section 27A, and also for offenses involving commercial quantities shall be released on bail or on his own bond unless the public prosecutor has been given an opportunity to oppose the application for such release. And where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. Now, this part of the thing, my lord, I will take your lordship to an appeals court decision of the honorable court can apply this provision. Now, my lord, before that, if my public prosecutor can satisfy your lordship that this accused person has a connection with the material which was recovered by Samsun Noor, there must be some connection or prior meeting of minds with the other accused person. Now, once these are absent, my lord, if you cannot make a connection with that, my lord, you cannot say that it was recovered from my position, because obviously it was not done that way. And what they have recovered from me, your lordship will find at page, the last page, your lordship, and page 61. This is the serial list. Undersigned do hereby seize the following descriptive items in connection with the case and a reference on being produced by from the possession of Anjan Nath. Description of the seizure: one Android mobile with save number so and so on. Nothing else, my lord. Now, your lordship will have the statement of the Mr. Anjan Nath on the section 161. Possibly there also he has stated that he was dealing with foreign cigarettes and Supari.
Page? Page?
Page, that is, my lord, in the record.
Oh,
your lord, public.
Here, the statement is there.
We'll
regarding the-
come to it. Then,
Now, my lord, I will just take your lordships to two decisions. One is of this honorable court and one is by the apex court. I take your lordship at paragraph 38 at page 317.
of which one?
Beg your lordship.
Which decision?
Citation is, my lord,
2005 SSC.
of 5 SCC 294. I'll rely on paragraph 38, 44, 46, and 49. I'll read paragraph 38 first.
33 or 38.
38, my lord. We are furthermore of the opinion that the restrictions on the
This
power
was
of the
concerning Muka,
Makoka, my lord, yes. Is in, my lord,
Maharashtra.
is a parameteria with this present act. We are furthermore of the opinion that the restrictions on the power of the court to grant bail should not be pushed too far. The court, having regard to the materials brought on record, is satisfied that in all probability he may not be ultimately convicted. An order granting bail may be passed. The satisfaction of the court as regards his likelihood of not committing an offense while on bail must be construed to mean an offense under the Act, and not only offense whatsoever, be it a minor or major offense. If such an expansive meaning is given, even likelihood of commission of an offense under section 279 of the IPC may debar the court from releasing the accused on bail. A statute described should not be interpreted in such a manner as would lead to absurdity. What would further be necessary on the part of the court is to see the culpability of the accused and his involvement in the commission of an organized crime, either directly or indirectly. The court, at the time of considering the application for grant of bail, shall consider the question from the angle as to whether he was possessed of the requisite mens rea. Every little omission or commission, negligence, or dereliction may not lead to a possibility of his having culpability in the matter, which is not the sanction one for retracting the provision of MECOCA. A person in a given situation may not do but which he ought to have done. The court may, in a situation of this nature, keep in mind the broad principles of law that some acts of omission and commission on the part of a public servant may attract disciplinary proceeding. I will also skip that. Now, paragraph 44, my lord. The wordings of section 21(4), in our opinion, does not lead to the conclusion that the court must arrive at a positive finding that the applicant for bail has not committed an offense under the Act. If such a construction is placed, the court intending to grant bail must arrive at a finding that the applicant has not committed such an offense. In such an event, it will be impossible for the prosecution to obtain a judgment of conviction of the applicant. Such cannot be the intention of the legislature. Section 21(4) of the MECOCA, therefore, must be construed reasonably. It must be construed that the court is able to maintain a delicate balance between a judgment of acquittal and conviction and an order granting bail much before commencement of trial. Similarly, the court will be required to record a finding as to the possibility of his committing a crime after grant of bail. However, such an offense in Futuro must be an offense under the Act and not any other offense. Since it is difficult to predict the future conduct of an accused, the court must necessarily consider this aspect of the matter, having regard to the antecedents of the accused, his propensities and the nature and manner in which he is alleged to have committed the offense. Then your lordship kindly see at paragraph 46. The duty of the court at this stage is not to weigh the evidence meticulously, but to arrive at a finding on the basis of broad probabilities. However, while dealing with a special statute like MECOCA having regard to the provisions contained in subsection 4 of section 21 of the Act, the court may have to prove into the matter deeper so as to enable it to arrive at a finding that the materials collected against the accused during the investigation may not justify a judgment of conviction. The findings recorded by the court while granting or refusing bail undoubtedly would be tentative in nature, which may not have any bearing on the merit of the case, and the trial court would thus be free to decide the case on the basis of evidence adduced at the trial, without in any manner being prejudiced thereto. Now, in paragraph 49, it is tried to know that personal liberty cannot be taken away except in accordance with the procedure established by law. Personal liberty is a constitutional guarantee. However, Article 21, which guarantees the above right, also contemplates deprivation of personal liberty by procedure established by law. Under the criminal laws of this country, a person accused of offences which are non-bailable is liable to be detained in custody during the pendency of trial unless he is enlarged in bail in accordance with law. Such detention cannot be questioned as being violative of Article 21, since the same is authorized by law. But even persons accused of non-bailable offences are entitled to bail if the court concerned comes to the conclusion that the prosecution has failed to establish a prima facie case against him, and or if the court is satisfied for reasons to be recorded that in spite of the existence of prima facie case, there is a need to release such person on bail where fact situation require it to do so. In that process, a person whose application for enlargement on bail is once rejected is not precluded from filing a subsequent application for grant of bail if there is a change in the fact situation. In such cases, if the circumstances then prevailing require that such persons be released on bail in spite of the earlier application being rejected, the courts can do so. Now, my lord, here in this case also, as a lordship has seen last 3 occasions, the bail was rejected. But then, my lord, it was not canvassed, which ought to have been done. Because here your lordship has seen the only ground of arrest is that, as per confessional statement by him, or it may be in the 161 statement also. Now, he used to deal with the foreign cigarettes and supari, there is barmit. Now, by any chance, at any cost, this is not coming under the narcotic drugs. Now, section 41C, it will have to be according to these acts.
The charge is not for foreign cigarettes. Charge is for some tablets.
Yes, now in that context.
We have to
my
have a
lord-
connect of you
No,
and
no,
the.
in that context, my lord,
Hmm.
they must connect me. Unless that is there,
No,
they
you're
have-
correct that in that line will,
yes, he
they-
has to reply that. Now, they have said the call regarding call data record. Now, call data record, whether any description is there, nothing. Your lordship will not find anything. Now, so far connection is concerned, my lord, to that extent, my lord, I will take your lordship a decision of this honorable court. My lord, they will have to connect me, whatever the materials they have. दीदी है क्या? ये मनोरंजन की कोई? ये तो दिया ना. My lord, I will take your lordships from paragraph 23, 24, 25, 26, and 27.
20.
23, 24, 23 to 27. my lord. Paragraph 23. After the arrest of the accused petitioners, a number of raids and searches were made in the house premises of these accused petitioners or in places stated to have been based on information elicited from these accused petitioners. On going through the materials, it is found that the materials and articles so far seized in this connection are Indian currency notes, the number of vehicles, mobile handsets, bank account passbook, bank check, ATM card, PAN card, etc. No narcotic drug or psychotropic substance has been found and recovered during such numerous raids and searches made so far during the course of investigation. Though serial of the mobile phone numbers of the arrested accused persons have been analyzed, no remark as regards establishing any link of the present accused petitioner with Shabir Ahmed or with the seized consignment of suspected brown sugar has been made. Thus, even except the statements of Shabir Ahmed and some of these accused petitioners recorded during their custodial interrogation, no other tangible and positive materials have been collected so as to establish a link or connection with either Shabir Ahmed and so and so, so and so. Then paragraph 24. The court is conscious of the fact that the clandestine business in narcotic drugs and psychotropic substances is usually carried out in an organized and secretive manner, and it is difficult to collect all the positive evidence within a short period of time. The offenses under the NDPS Act are serious in nature as it affects the whole society, and it is in that view of the matter, provisions have been incorporated therein for a period of custody of a person accused of certain offenses under the Act longer than the period provided in the CRPC. The purpose of interrogation of a person suspected of such offenses is to elicit useful information and materials so as to give an opportunity to the investigating authority to direct its investigation in the right direction in a meaningful manner. It is also to be noted that the investigation of the case in hand is being carried out since so and so, and a substantial period of time has elapsed in the meantime. But till date, except as mentioned above, no other positive materials have been collected or unearthed so as to link or connect the present accused petitioners with the activities related to prohibited drugs. The available materials as on date are in the form of inculpatory statements of the arrested accused persons, including the present accused petitioner, which have been recorded during their custody. Apart from the above and other than the accused petitioner, Kabir Ahmed, nothing has been brought to the notice of this court that any of these accused petitioners has been found involved in connection with the drug business, accused or arrested in connection with the case of NDPS at any point of time. In any one case, he was not charged, and the other one is not in respect of any offense under the NDPS Act. In view of such a fact situation, obtaining no exception will be taken as regards criminal antecedents of the accused petitioner so as to arrive at a finding that if released on bail, he will commit any offense under the NDPS Act. One of the accused persons of Badarpur Police Station number so-and-so, released by a coordinate bench of this court by order date to so-and-so, passed in bail application on the ground. The materials in the case diary did not have any material to suggest the involvement of the state accused person in the case. On perusal of the materials in the case diary, it is found that the state accused person was arrested on the basis of similar accusation as like the present accused petition. Section 25 of the Evidence Act is specific to the effect that no confession made to a police officer shall be proved as against the person accused of any offense. The NDPS Act does not contain any provision which overrides Section 25 of the Evidence Act. The Honorable Supreme Court of India, Criminal Appeal number so-and-so, decided in so-and-so, has observed that to arrive at the conclusion that a confessional statement made before an officer designated under Section
There is no dispute to 25.
Yes,
25 we
there
are
is no
not,
dispute. My lordship may speak.
161, we are not, this is only on the investigation stage.
Yes, my lord.
We are
but
not
then-
basing any conviction based on an investigation statement made in the investigation.
My lord,
We are
so
only
far,
considering the bail.
right. So therefore, my lord, my learned friend will have to satisfy your lordship how he is connected
Correct.
relating to the recovery of that. This is if he can convince your lordship of the materials and record, that's a different part. And whether call letter records are, those records are there at all. Merely saying that from the phone call you have got to know his connection with such and such, that will not do. The entire records will have to be there in order to convince your lordship that he is really involved in that.
Yes.
May I please your lordship, my lord? Lordship, here, my lord, first, my lord, lordship is to see, my lord, the gravity of the offense. That is, my lord, now 2,59,000 tablets have been recovered. That is one part, my lord. And secondly, my lord, I pray your lordship to see page number, my lord, 40, my lord.
40.
40, my lord, lordship, my lord. Last order, my lord. Lord, 43, lordship. 40, page 43, lordship. Why I'm saying so?
Yes.
Yes, on the, my lord, just second paragraph, my lord. On the other hand, by referring to the scanned copy of the case records, including the earlier order dated 13/5, Certain learned PP has submitted that this court on the earlier occasion had recorded the connection of the petitioner, including his call record with one Abdul Fattah, who is an absconder. Learned PP has also submitted that the petitioner worked in close connection with another accused, Philip Day, which is revealed from the case record. The quantity of the contraband involved, which is a chemical drugs, wherein the total quantity is 2,59,000 of tablets in all, is also a relevant consideration. In view of the court is a different view taken on substance as death. Further, Section 37 of the NDPS Act lays down that before granting a bail, the relevant factors are that court should come to a satisfaction that prima facie the applicant is not guilty of the offense, and also the applicant has to satisfy the court that in case bail is granted, he is not likely to commit further offense. The aforesaid two factors are seem to be fulfilled in present case, and that because my lord, the bail rejected, my lord. Why I am saying the regarding the Abdul Fattah, my lord, the lordship will see from the, my lord, page 18, lordship will kindly, my lord, the FIR, my lord, what it revealed, my lord.
1-8.
1-8, lordship. 1-8, lordship. Your lordship will find, my lord, after the seizure part, my lord, 1 1, 2, 3, 4, 5. After that, Lordship, see, thereafter, I packed the seized exhibit at PO and sealed the same in presence of witnesses and handed Zimma of the weight machine to its owner. Accused Samsul Noor was apprehended and brought at PS. We returned at PS with this exhibit and apprehended person at 9:45 p.m. During questioning, the apprehended person named two escaping drug dealer, that is Abdul Fatah, son of such and such, address is given. And the seized Yamaha bike belonged to Abdul Fatah, and they came to the house of Samsul Noor for drugs deal. This paragraph, your lordship will find that Samsul Noor and Abdul Fatah, from where the drugs were recovered, my lord. And along with them, Abdul Fatah is also there. And that Abdul Fatah used to take drugs from this Anjan Nath, my lord. This is a chain of, my lord, events, my lord, and it is
Now, from where do you make this statement?
regarding, my lord.
That Anjan Nath is connected. He was mainly
yes.
emphasizing on the connection.
Yes, connection, my lord, that will reveal from their lordship, Anjan Nath's statement, my lord, and
Where?
also in the last, I have flag mark, my lord, call records, my lord. I have flag mark.
This is Philip.
Yes, and another is, my lord, Anjan Nath. My lord.
Anjan Nath, yes.
Yes. Your lordship will find, my lord, I have just underlined, my lord. The name of your lordship will find, my lord, Abdul Fatah, my lord. And that person is so notorious, my lord. Now he is yet to be, my lord, arrested, my lord. He is now an absconder.
Fatah.
Fatah, my
No, no. My lord, that position is not correct.
lord.
Your lordship, kindly see page 54. My lord, public prosecutor should be careful in making such submission. He's holding a responsible
54,
position. my lord.
50.
54.
Which part?
But such statement,
No, that's okay.
very unpleasant, my lord.
Doesn't matter.
Submitting from a
Where is the
record,
High
my lord.
Court's order?
If it is there in the record, my lord,
High Court's record, of course, I did not annex that. Lord, as a lawyer, we understand, my lord, we shall project the correct position.
yes, my lord. Regarding that, I am not facing. I am just, my lord, bringing that chain of events, my lord. How, my lord, and you also find from the statement, my lord. Your lordship has seen the statement of Anjan Nath, my lord. And his Abdul Fatah's, my lord, his also bike has been seized from the place of occurrence, my lord. And he is linked to, my lord, Anjan Nath, my lord. This is the linkage, my lord, That is why, my lord, he is also, my lord, succeeded. And your lordship will find, my lord, that the case is not not only under 22C, it is also under section 29, my lord, which reveals, my lord, conspiracy, my lord. And, my lord, it is not that, if, my lord, he is not accused is not in a conscious position, my lord, he cannot be, my lord, succeeded. It is, my lord, constructive position also, my lord, which is has to be recorded. That
Lord,
has
so
been, my
far-
lord, that
so
is-
far conspiracy is
my-
concerned.
more political. Let my argument finish, my lord.
You have said that the conscious position is not necessary.
Not necessary.
Constructive position is also
Yes, yeah, and
enough to bring it in the ambit of the act.
ambit of the act.
And you say that
I-
in the statement of 161, Anjan Nath has
Yes,
connected himself with Fatah.
Fatah, my lord. And that is relevant at this stage, my lord. I am not saying about the criminal, whether he will be convicted or not. That is a separate part, my lord. But I am on the, my lord, bail, my lord. Today we are, my lord, deciding on a bail, not on criminal petition or not any other, my lord, criminal appeal, my lord. My learned senior friend has referred to some, my lord, judgment, my lord, which is lordship has found it regarding criminal appeal, my lord. There's some observations I made, my lord. And that is one part. And secondly, my lord, regarding the section, my lord, section 41, my lord, my senior friend is, my lord, referring, my lord. Section 41 and section 37 are two separate sections, my lord. Section 37 is a very clear section. It cannot be read conjoined with section 41, my lord. Section 37 is, my lord, very specifically, my lord, it has been inserted only to stop the menace of, my lord, drug peddling, my lord. It is a special section, my lord. And your lordship will see, my lord, the regarding, my lord, and another judgment, my lord, senior friend has given 2005 regarding 294, my lord, where the learned friend is praying of some other act, my lord, and that has been considered, my lord. So here, my lord, what I have to submit, my lord, in, my lord, NDPS, my lord, there is a difference between, my lord, degree of satisfaction, my lord. Whether, my lord, there is two part, my lord, whether, my lord, an accused is guilty of an offense and whether he is prima facie guilty, my lord. There are two separate things, my lord. Here, my lord, the satisfaction is more stringent in section 37, my lord. Here your lordship has to record that he is not guilty, my lord. Prima facie, he is not
Prima
guilty.
facie is not guilty.
Not guilty, my lord. And in future also, he is, my lord, unlikely to commit crime, my lord. These are two very stringent provisions which the court has to satisfy. My lord. It is not that whether he is prima facie guilty or not. It is not that, my lord. It is, my lord, whether my lord, he record that whether he is not guilty, my lord. That has to be recorded. That is a very, my lord, the degree of satisfaction is very much different with in NDPS Act, my lord. That is why, my lord, the learned friend, my lord, referring to 2005 this judgment, my lord, it has no relevance with this case, my lord. And my lord, there are something it has been stated that a culpability of the accused has to be, my lord. The culpability has to be, my lord, decided from the case record, my lord. It has prima facie linked with the main accused, my lord. That is one part, my lord. And secondly, my lord, and then regarding, my lord, another thing, section 37, my lord, I rely on, my lord, one judgment, my lord, that I have NCB versus, my lord, Mohit Agarwal's case.
Just a minute, just a minute.
Why, my lord, the court cannot ignore the section 37, my lord?
Just a minute.
Lost.
One
Lost.
Mr. Goswami,
Yes.
this Mokoka Act, the provision is almost perimeter
All-
21-4.
Wait, yeah.
If you have a copy of the judgment,
Yes, I have
Mr.
not- I have
Doctor,
not-
can you
I have not-
pass over the
Yes,
judgment?
yes,
Mm. You come to page, internal page. This would be page 17,
Paragraph 17, Lord.
page 17.
Lord,
Page is on the top,
317 or
the Mokoka case.
Yes.
It pertains to an ex-commissioner of police.
Mokuga case.
Page 17. Pages are on the top, just
Yes,
after
yes, yes.
SS. 17, have you found? 16 onwards, the various provisions of the Mokoka has been verbatim projected, and 21-4 is at page 17. The pages are on the top, Mr. Doctor, on the top left side, pages, page numbers.
Yes.
17, this small, written very small.
317, Lord.
Huh?
317.
Not 317, what 317?
17.
Page 17 of the judgment. Citation.
Page 17.
The Ranjit Singh case.
Yes, Ranjit Singh.
This is the Telgi case only, that scam. Stamp paper scam of Maharashtra.
Stamp paper scheme, yes.
He was this
Maharashtra.
person was a former commissioner of police.
Yes, yes.
Ranjit Singh. At page 17. Have you got?
I have found.
Not found 17.
Yes, my lord, it is the citation is, my lord, 2005 5HCC 294.
Correct.
Yes.
You come to internal page 16.
Yes, sir.
17, internal page 17.
No.
Because this is a OCC online copy. Are you given the same copy to him?
Same. No.
Internal page 17.
No.
Have you found?
Yes, Lord.
You will get 21-4 there.
Yes, Lord.
Just read, notwithstanding anything contained in the code, no person accused of an offence under this act shall, if in custody, be released on bail,
Yes.
unless conditions are similar. Public prosecutor had been given an opportunity.
Yes, sir.
Public opposes the bail, the court is satisfied there are reasonable grounds for believing that he is not guilty
Not, yes.
of such offence
Yes.
and is not likely to commit any offence
Yes.
while on bail.
And that's also, yes, sir. Yes. The text of the case, my lord, whether he can be linked to the other accused persons who are also similarly, my lord, he was charged, my lord. So, as per that, my lord, the lordship will find from the record, my lord, his culpability is, my lord, proof from the statement, his own statement, and also the fact that the Bashir Khan is also there at that point of time while the seizure is made, my lord.
Now Fateh has been released. Fateh has been released.
My lord, I am not questioning whether he is released.
No,
or
no,
not.
Fateh has been released. It's
Yes,
a matter
I
of
know, yes,
it's a matter of fact.
Yes, ma'am.
And he says that apart from his statement under 161,
Yeah.
that there are CDR with other accused.
Other accused, ma'am.
And the main accused, and Fateh was the main accused.
Lord.
Under those circumstances, other than his statement, is there any detail of CDR?
Okay. Details of CDR from that is, my lord,
From Anjan to
from the, my lord, the record have found that, my lord, that the CDR analysis, my lord, report reveals, my lord, they are in link with the other accused persons.
where is it?
From the, my lord, last pages. And it is also very much clear from the statement that, my lord, from where he got this contraband, he said, my lord, he also admitted that were taken by, my lord, this other accused person, my lord, that is
Please,
Fatah, my lord.
The tablets were seized from whom? Sir
Tablets
Fateh?
were seized from my lord, one
Samsul,
Samsul and
Samsul.
another one person, my lord. And there, at that time, my lord, 4 accused as part of my lord forwarding. 4 persons are there, my lord. Other person managed to escape, and 2 were apprehended later on, my lord.
One Yamaha motorcycle.
Mm.
carrying
And Abdul Fateh's, my lord, bike has been seized from that place of offense, my lord.
So we'll take a call.
In your lordship, may I cite one judgment, my lord, regarding
Yes, one you have given.
Yes,
Yes,
criminal
Mohit
offence.
Agarwal.
Mohit Agarwal, my lord. Here, my lord, paragraph 11, my lord. I just want to, my lord, refer, my lord. It is evident from a plain reading of non-abstinence clause inserted in subsection 1 and the conditions imposed in subsection 2 of section 37 that there are certain restrictions placed on the power of the court.
Para 11.
Sorry, lordship.
Para 11.
Yes, lordship, para 11. Lord.
Yes.
It is evident from a plain reading of non-abstinence clause inserted in subsection 1 and the conditions imposed in subsection 2 of section 37 that there are certain restrictions placed on the power of the court when granting bail to a person accused of having committed an offense under the NDPS Act. Not only are the limitations imposed under section 439 of the Code of CRPC 1973 to be kept in mind, the restrictions placed under clause B of subsection 1 of section 37 are also to be factored in. The conditions imposed in subsection 1 of 37 is that public prosecutor ought to have given an opportunity to oppose the application moved by an accused person, and if such an application opposed, then the court must be satisfied that there are reasonable grounds for believing that the person accused is not guilty of such an offense. Additionally, the court must be satisfied that the accused person is unlikely to commit any offense while on bail, my lord. This is also very, my lord, stringent, my lord. The court has to record that he is unlikely to commit any offense while on bail, my lord. And that this reasonable expression has come up for in the next paragraph. And what is the reasonable grounds?
Grounds.
Has come up for discussion in several rulings of this court in such and such versus Nadira, a decision rendered by 3 judge benches. The limitations on granting a bail is only when the question of granting bail arises on merits. Apart from the grant of opportunity, the other 2 conditions which really have relevance so far as a present accused person is concerned are the satisfaction of the court that there are reasonable grounds for believing that the accused is not guilty of the alleged offense and that he is not likely to commit any offense while on bail. The conditions are cumulative and non-alternative. The satisfaction contemplated regarding the accused being not guilty has to be based on reasonable grounds, and there are the reasonable grounds, but that is stated, my lord, keeping it. And my lord, another judgment, my lord, which regarding, my lord, just I have to refer to my lord. State of my lord, criminal miscase bail application number. Why am, my lord, I just want to refer to what it was stated in the, my lord, in page 3, your lordship may, my lord, take it up, my lord. That has been, my lord, one observation. It was, my lord, recorded in Union of India versus Ram Sambhiya 1999 supply 2 my lord. Here, my lord, what is stated regarding the meaning of, my lord, the drug peddling and the effect to the society, my lord. Why it is so stringently, my lord, considered, my lord. May I read, my lord? It is to be borne in mind that the aforesaid legislative mandate is required to be adhered and followed. It should be borne in mind that in murder case, accused commits murder of one or two persons, while those persons who are dealing in narcotic drugs are instruments in causing death or in inflicting blow to number of innocent young victims who are vulnerable. It causes deleterious effect and deadly impact on the society. They are hazard to the society. Even if they are released temporarily, in all probability, they would continue their nefarious activities of trafficking or dealing in intoxicant clandestinely. Reason may be large stake and illegal profit involved. This court dealing with the contention with regard to punishment under NDPS Act has specifically observed about the adverse effect of such activities in such and such cases. With deep concern, we may point out the organized activities of the underworld and the clandestine smuggling of narcotic drugs and psychotropics in the country, and illegal trafficking in such drugs and substances have led to drug addiction among a sizable section of the public, particularly adolescents, students of both sexes, and the MINEC has assumed serious and alarming proportion in recent years. Therefore, in order to effectively control and eradicate and proliferating and booming devastating manner causing deleterious effects and dealing impact on the society as a whole, the Parliament in the wisdom has made effective provisions by introducing the Act of 81 of 1985, specifying mandatory minimum imprisonment and fine. To check the MINEC of dangerous drugs flooding the current market, the Parliament has provided that the person accused of offences under Section NDPS Act should not be released on bail during trial unless mandatory conditions fulfilled. And another, my lord, regarding the other co-accused, my lord, my learned senior friend is referring, my lord, regarding Philip Day, my lord. With all respect, my lord, the learned court, while dealing with the, my lord, though it is stated that, my lord, it is been, my lord, stated that they are all involved with the case, my lord, but it is also stated that 37 may not applicable, my lord, in Anjan Nath case, my lord, and but it was not elaborately, my lord, specifically, my lord, why it is not, my lord, attracted, my lord, with all respect, my lord. So, my lord, and my lord, regarding the status, my lord, there is no, my lord, thing as a parity, my lord, in, my lord, criminal trial, my lord. Regarding the Anjan Nath and, my lord, this accused, my lord, another accused, my lord, their status is different. It is figure.
You want to say there is no question of parity?
There is no question of parity regarding, my lord, in, my lord. It is the satisfaction of the court and also the regarding involvement, my lord, what the court has to think.
When was he arrested?
He was arrested on forwarding his, my lord, 15/3, I suppose, my lord.
15/3/2022,
22.
and today is 525
Only
days.
prayer, my lord, I have, my lord, later, my lord, if a lordship for a speedy disposal and for consider at least the consideration charge.
What is the stage of the trial?
It is in the stage of consideration of trial charge, my lord. Not yet, my lord. Because one of the accused I have found, my lord, he has preferred some application before the Honorable High Court, my lord. So for my criminal I think criminal petition or revision, my lord, I have hurriedly checked, my lord. In the last order, it is reflected in the.
Lord,
And
I'll
it
just
can
take
be,
one.
my lord, just ordered that let the charge be framed, and if he is not charged, my lord, if this fact can be brought before my learned senior friend in that court while dealing with the charge, my lord, at that time of hearing of charge, my lord, then the matter is surprised, my lord.
Yes.
If your lordship look at page 18, my learned friend wanted to link.
18 of?
No, whether 18 of
Petition.
my petition, my lord.
Yes.
My learned friend want to say that this is the link. I hardly believe that, my lord. Now, your lordship, can this is the last three lines. During questioning the apprehended person named two escaping drug dealer to be Abdul Fatah. The seized Yamaha bike belonged to Abdul Fatah, and they came to the house of Samsul Noor. How he is linking with this? Now, my lord, section 29 deals with conspiracy. Now, in order to, my lord, bring home in the provision the conspiracy, my lord, there must be prior meeting of mind. These are all absent here. And the second thing, telephonic conversation with the Abdul Fatah. Now, what is the conversation? Whether you have collected all data records, nothing. Your lordship will not find in the case diary all these things. Now merely making submission of all that, that is connected because Abdul Fatah came with a bike, whether he came with this narcotic drug, is nothing is there. And what is seized from him? Only mobile. And his position, my lord, status, so for Anjan Nath and the Philip, they are in the similar status, my lord. And he was granted bail because, my lord, the foreign cigarette and the Burmese supari was confiscated from their house. So this is the only material against them. And conspiracy also not coming, my lord. Your lordship may note one citation, 1999, 3 SCC, page 54, paragraph 11. In order to bring home the charge of conspiracy, what the prosecution has to do. 1999, 3 SCC, page 54, paragraph 11.
Name?
Name, what is the name? Vijayan versus State of Kerala. Therefore, my lord, there is nothing on record to make connection with this person with Mr. Samsun Noor, who is the prime accused. And all of them has been, even the 3 absconder, the lordship is saying they have been granted bail. And learned PP is so much arguing vehemently, even saying that Fatah has not been granted bail, although he was granted bail.
No, we have records are there.
But therefore, my lord, it's a case where, my lord, these act is
Okay,
very
we'll pass on.
stringent.
We'll pass on. today.
Your lordship may kindly record one thing, paragraph 7 of the Mohit Agarwal case, where my lord, constructive possession is discussed. My lord. Paragraph 7.
These are settled position, my lord. These are, nobody is disputing that.
Because my learned friend is saying that only my lord mobile has been my lord seized, my lord. The seizure is not a part here, my lord.
Let him satisfy from the materials on record. Only he is saying, nothing is on the record, my lord.
We'll check the record.
Let him be fair.
We'll pass the orders.
My
Lord,
As the civil court has directed to approach before the Delhi court. So we want to withdraw.
You had filed an IF for stay vacating.
Stay vacating.
Okay. Your name?
DK Sharma.
Sri DK Sharma, learned counsel for the appellant, submits that he has instructions to withdraw this appeal. Full stop. Also heard Sri D. Bora, learned counsel for respondent number 1, who does not have objection to the said prayer. Full stop. Para. Appeal according to distance dismissed on withdrawal. I got a
Interim order passed on
distance interim order passed in the connected. I stands vacated.
dated 15/3/2023.
15/3?
2023.
I cannot be keeper in view of the circumstances or don't I for stay over. Interim order stands vacated.
Highly obliged.
Yes. Yes, Mr. Mohanta. Magamdar, why is nobody present here? It's no question. Your names are shown.
Yes, sir.
This is a matter assigned to this bench.
Yes, sir.
If you are not appearing, we'll proceed in accordance with law. We are not required to call you time and again. From 10:30 to 2 o'clock, we wait for you. That is not our job. We'll proceed in accordance with law from next time. First time we are taking an exception.
I apologize again, my lord.
If names are not shown, this is a top of the list matter. You have to give preference to this. We understand we are not taking bench two, but this matter has been assigned to this bench. And if there's only one, there is not a concept that there's only one council. You have a set of council. Yes, what is it? You have not filed affidavit here.
I have seen now, we have received some instructions, but those instructions are only on 2 paragraphs of the.
But what about your commitment? You had made some,
We have, from what the instruction says, by the time the judgment came, we had only 16 vacancies left. And it was those vacancies that we had called them for.
Yes.
Now, since those vacancies were again in some particular categories that those vacancies remain, therefore, my lord, this situation has arisen where they say that they cannot appoint, they cannot.
you don't
participate
have to
in-
adjudicate because we had refused the interim order only on the commitment that vacancies are there, they will be accommodated. Now, if
The
you say
vacancies-
something else now,
Vacancies as it stood on the date of the judgment by this honorable court, those were the vacancies which we could afford to the petitioners. If they do not fall within the cutoff, or if the vacancies are not
it was not
available
a
in
condition,
particular category.
not a conditional undertaking. You said that there will be vacancies, they can be accommodated. Or they would be accommodated. Now, if the accommodation is also conditional, then we'll adjudicate.
Lordship have it on Monday next, my lord. I'll have a clarification.
Tuesday
on
next,
that.
Tuesday next,
I'll have a-
Tuesday next.
I'll bring a.
Cards free. K.K. Mohantalan, senior counsel for the petitioner, who has informed this court. Who is 3 to 7? Who has informed this court that the department is yet to file any response. And this matter is pending since November 2022. Sarah? Three R. Madhumdar, learned training council, elementary education department submits that do certain instructions have been received, comma, the same do not appear to be adequate, and he prays for some accommodation for Kapara. In the interest of justice, now considering the subject matter involved and the orders passed by this court from time to time, comma, let this matter be listed for consideration on
25th, my lord. That is Tuesday.
on 25th. 25th.
My name may be reflected.
Yes, Laskar, M.H. Laskar is present for the response numbers 3 to 7.
And they will be made to dispose of.
Oh, we will understand that.
Yes.
Will come out of the list.
I'm obliged.
Okay.
May it please your lordship. The second appeal is preferred by the defendant. It is preferred against the judgment of reversal. The suit was by the.
You have produced the cross-examination of the appellant.
My lord, I have. I have given the translated copy also.
This is for no? Yes, so what is your case?
Yes, ma'am. This suit was by the respondent, my lord. The suit was. for
You are the defendant in the suit.
Yeah, defendant in this. This suit was for declaration of possessory title and right, my lord, and recovery of possession and injunction in respect of government land, my lord.
measuring 3 kata out of 9 meter. Okay. My lord, the allegations made in the plaint are contained in para 3, 4, and 5 and 6, my lord. Who are you? My lord, my land is towards the north, my lord, of the government land. I'm possessing my patta land where I'm having my house, my lord, and I'm possessing the stoop land also, where I'm having certain temporary structures. That is it. My lord, what the plaintiff, my lord, the respondent that claimed, my lord, that I had dispossessed them, then there was a compromise in a mail, my lord, where I initially assured them to vacate the premises. Thereafter, I rescinded back, my lord. I did not vacate it, and hence the suit, my lord. Now, my lord, since the suit was for declaration of possessory right and title, my lord, but they did not title. Possessory title and right, my lord. Possessory title. Possessory right, not title. My lord. Title. My lord. That is what is pleaded in the plaint. That is I'm submitting, my lord. Now, during the trial, my lord, they did not produce any annual patta, my lord, because our Honorable High Court in the year 1994 has said, unless there is a settlement, as per the settlement rule, there cannot be any declaration of possessory title and right, my lord, in respect of such land. What was produced, my lord, if your lordship would see, at page number 25, the list of exhibits. Yes, my lord. It is part of the lower court judgment, my lord, trial court judgment. There the list of plaintiffs exhibit is mentioned. Exhibit 1 and 2 are the land revenue paying receipts, my lord, dated so and so and so and so. So these were the documents, my lord, that were produced. There was no annual patta produced by them. And on the basis of these two documents, my lord, ultimately the appellate court has declared the possessory right over the land, my lord. But what documents did you have? My lord, I did not produce any document. I am in possession of the same. It is not my case that the government has issued an annual patta to me. It is a government land. I am possessing, my lord. The burden was on them to show that I had dispossessed, my lord, and they had said that there was a Samajnama, my lord. That also they could not produce, my lord. If your lordship would see. The suit was also for recovery of possession. Yes, my lord. Recovery. Yes, my lord. And why, what injunction? My lord, not to disturb their position. My lord, that relief, my lord. No, if it is a recovery suit, what is the question of disturbing? My lord. Prayer is at page number 65 and 66, my lord. 65 and 66, my lord. Yes. Here, a decree for declaration of possessory title on the scheduled land, as they have continuously been enjoying the possession of the same for a long time. A decree declaring the defendant has no right to dispossess the plaintiff of the stoop land. And for delivery of khas possession. My lord. Delivery of khas possession of the said land to the plaintiff by getting the 85 feet long bamboo fence removed from the scheduled land for a permanent injunction against the defendant, so that the defendant or anybody engaged by him cannot evict the plaintiff from the stoop land forcibly. My lord, in the plaint in clear terms, the date of dispossession is not stated, my lord. The exact date of dispossession is not stated. And whatever comes out, my lord, from para 5 and 4, 5 and 6 regarding the compromise, my lord, that compromise document, my lord, that was also not exhibited. Now, the reason why I was asked to produce, my lord, the cross-examination of the appellant is that, my lord, in para 13, my lord, of the appellate court's judgment, page number 51. Page number 51, para 13. Here, my lord, the appellate court has observed
Learned trial court below did not discuss anything in regard to the part of cross-examination that done upon DW1, namely Sahabuddin, because in his cross-examination, he admitted that in a Samajnama was conducted by the public at large. He assured that he will not obstruct the appellant in regards to his possession of upon the suit land. My lord, this part is perverse, my lord, to the evidence of
This is a case of reversal over.
my lord,
Trial court had dismissed.
my lord. That's why, my lord. So, my lord, first, my lord, substantial question of law that I would like to press, my lord, is substantial question number 5 at page number 8, my lord.
Yes.
Yes. For that, the substantial question of law is whether the Bedakal Jorimana receipts have any recognition in the eye of law so as to be sufficient enough to grant the relief of declaration of possessory right and title in favor of the plaintiff, and if not, whether the first appellate court below was right in allowing the appeal in favor of the plaintiff. This is the first substantial question of law. Second, my lord, though I have not formulated, but what transpires from the record that the findings in para number 13 of the appellate court judgment appears to be perverse to the evidence. That is the cross-examination, my lord. I have not made any.
But how will this go to help you? Question number 5. This Bed Dakalkari Jorimana is just a Toji,
my lord.
isn't it?
Yes, my lord.
Toji is not recognized by the eyes of law.
My
But
lord.
this is not with regard to any title.
My
This is
lord.
only with regard to the position.
My lord.
How is it going to help you?
My lord, there was nothing to show regarding their possession, my lord. That is my case, my lord. Before your lord.
Paying the Toji
My lord,
in their name.
my lord, Fauzi, that is the thing, my lord. Here the appellate court has declared their possessory title, my lord. If your lordship would come.
We change the nomenclature title to possessory right. Or does it will you get any relief? You are not going to get any relief by that.
Yes, my lord. Definitely not. They are not entitled for any relief. I being the defendant, my lord, that is my case, my lord. I was the defendant, my lord. There was nothing on record to show that I had dispossessed them, my lord. Because it is for recovery also, my lord. Relief for recovery was also sought.
In the plain, there is no statement of disposition.
My lord, no, not in clear terms, my lord. Your lordship basically.
There was a threatening of disposing, then there was a mail on such and such date.
My lord.
So how is it going to help you actually? Even if the substantial question of law is decided in your favor,
my lord.
it does not vest them any right, any title.
Yes, my lord. Yes. Yeah, I was the defendant, my lord. The trial court had rightly.
Where are the issues? Let us see.
Issues, my lord. My lord, issues your lordship will find mentioned in both the judgments. My lord, trial court judgment issue is at page number 16, my lord.
16.
Yes, sir. Page number 45. My lord, serial would be 45. Internal is. Issue number 3 and 4 are the pertinent issues.
Let us see the discussion.
Yes, my lord. Issue number 3, discussion starts from page number 9. Internal page number, my lord, would be page 19, my lord. Page 19 is the trial court discussion, my lord, on issue number 3, whether the suit land is possessed by the plaintiff since 22 years back. Here, my lord, from the evidence of record and also from the arguments of the plaintiff's counsel, it is found that the plaintiff has relied
Where are
upon,
you reading? Where are you reading?
my lord, page number 19, my lord.
Page number 19 of,
The trial court judgment. Period page number. Start from bottom. my
running
lord,
page 19.
Running page 19.
Yes.
Whether the suit land is possessed by the plaintiff since 22 years back.
Hmm.
From the evidence and record and also from the arguments of the plaintiff counsel, it is found that the plaintiff has relied upon Exhibit 1, 2 and Annexure 3, Exhibit 4 and Exhibit 5 to prove his possession over the land since 22 years. Now let me scrutinize the evidentiary value of the same. All the said exhibited documents are being objected by the defendant. It is well settled that when the documents are objected by the opposite side, the party relying upon them has the burden to prove the same. Exhibit 1 and 2 are two land revenue paying receipts. Actually, those are not revenue paying receipts in actual sense of the term, but those are receipts of Bedafali Jurmana admitted by the plaintiff receipt. The said documents have no recognition under the relevant land laws of the state. Further, except mere exhibiting the said documents, the plaintiff has not proved the same by adducing evidence of any person who had issued the same or by any other means recognized by law. So the said two documents are not proved as per the Indian Evidence Act. Annexure 3 has not been specifically exhibited by the plaintiff. That is, he has not used the term exhibit, as merely mentioned in his affidavit of examination in chief, but has relied upon the same. Admittedly, the said document is a mere photocopy and the original has not been produced. Although law provides for adducing secondary evidence relating to a document, the same has to be in conformity with Section 65 of the Indian Evidence Act. It is well settled proposition that the secondary evidence of an ordinary document is admissible only and only when the party desires of admitting it has proved before the court that it was not in his possession or control of it, and further that he has done what could be done to produce the production of it. Thus, the party has to account for the non-production in one of the ways indicated in Section 55 of the Evidence Act. The party further has to lay down the factual foundation to establish the right to give secondary evidence where the original document cannot be produced. But here in this suit, nothing has been done by the plaintiff side for admission of secondary evidence. As such, the said document is inadmissible in evidence. So far, Exhibit 4 is concerned, the same is nothing but an application intimation made to PW3.
Okay. So the suit was dismissed.
Suit was dismissed.
And how has the evidence been reappreciated by the appellate court?
Appellate court, my
So
lord.
that the
Yes.
Bedakhal Kari Jarimanas are concerned.
My lord. Points of determination is at page number 46.
Yes.
Upon hearing of both sides, following points need to
Yes.
to determine whether the judgment and decree passed by the learned Munshif number 1, Darang Mongoldo in title suit 147/13 dated 15/6/2000.
What about 2? Let us see 2.
My lord, yes. My lord, at page 46, the discussion in respect of issue number 3 of the trial court starts. Seen that the learned Munshif number 1 has correctly decided issue number 1 and 2 in regards to maintainability of the suit and the presence of cause of action in the suit. Those issues are therefore affirmed to be correct. While deciding issue number 3, learned court below took into consideration the objection raised by the respondent in respect to Exhibit 1 and 2, which were revenue paying receipts, and it is opined that those are not revenue paying receipts in actual sense, but receipts of Bedafali Jurmana. And those two exhibits have no recognition under the relevant land laws of the state. It is also opined that except exhibiting the two documents, the plaintiff did not prove the same by adducing evidence of any person who had issued the same or by any other means recognized by law, and ultimately it was held that the two documents are not proved as per Indian Evidence Act. Learned trial court below did not give any importance or discuss the provisions of section 74 of the Indian Evidence Act in regards to the definition of public documents. It is true that exhibit 1 and 2 are revenue paying receipts, and those are issued by the Mojadar as per Rule 120 of the Assam Land and Revenue Act in chapter pertaining to executive instruction. It is defined that the Mojadar is a public servant whose primary duty is to collect the land revenue and other government duties, with collection of which he is entrusted. Therefore, exhibit 1 and 2, which are issued by Mojadar, becomes public document within the meaning of section 74(3) of the Indian Evidence Act, and in respect of such documents, no separate proof is required as regards to the provisions of law. It is true that the exhibit 1 and 2 are Bedapuli Jurmana receipts, and the very suit of the appellant is in respect of government land, and in such land, Bedapuli Jurmana is realized as penalty from the possessor. Therefore, such documents are to be appreciated for the purpose of deciding any right asserted over the government land. So, as far as exhibit annexure 3 and exhibit 4 are concerned, those are rightly appreciated in regards to their status in accordance with law. But when appreciating exhibit 5.2 with the chitta entry, the evidence of PW4, namely Shri Uday Sharma, the Lot Mandal of Pathari Ghat Revenue Circle, Sipajhar, was not properly appreciated. PW4 in his official capacity deposed from exhibit 5.2 in regards to the endorsement of the name of the appellant in respect of the scheduled land, and on his cross-examination, he admitted that exhibit 5.2 is written by pencil. He went on to admit during further cross-examination that normally the fact of possession is written in the column of comments, and it is written in pen and ink, but sometimes with pencil also. He stated fairly that he had no knowledge about exhibit 5.2, and he went on to admit that on his inspection of the suit land, he did not found possession of the appellant, that is the plaintiff's minor, on the suit land. And this very fact is clear indicator and clear proof to the prayer made by the appellants in the plaint in regards to his dispossession from the suit land. And how that can be made? That the learned trial court below did not give any consideration to the prayer of the appellant seeking recovery of past possession, and an alternate meaning was taken into account because PW4 in his cross-examination admitted that there was no possession of the appellant, which interpreted the fact of the appellant in regard to his disposition. So this was the discussion in respect of issue number 3, my lord. And 4, my lord, at page number 51. My lord, I would like to place this judgment, my lord, of our head note says that the right over Tozi land, the person cannot acquire any right and title over Tozi land until settlement is made by the authority. Para 6, my lord. So it is an admitted position that no settlement was done in their favor. So as to seek any possessory title or any right, my lord, either against the government or against me also. I am possessing the land, my lord. Government will come and evict me. There is no problem to that, my lord. But if there was a settlement in their name, my lord, annual quota was settled in my name, then the question would have been different, my lord. And only on the basis of those Jurmana receipts, my lord, the possessory right or the title, whatever, my lord, cannot be declared. And regarding to the suggestion, my lord, that was put by the plaintiff's counsel to me, my lord, that, my lord, I have given the cross-examination. The last page, my lord, if I may read in the vernacular thing, my lord, I have denied that suggestion. The last page, my lord.
Yes.
সত্য নহয় যে 15/7/12 তাৰিখে এখন সমাজ হৈছিল আৰু সেই সমাজ নামৰ সিদ্ধান্ত মতে মই বাদীক বিবাদীয় মাটি বাধা নিদিও বুলি ৰাষ্ট্ৰ দিছিলো। সত্য নহয় যে আশ্বাস দিছিলো। I have denied to that suggestion. There was no admission on my part. So that observation, my lord, or that finding in para 13, my lord.
Where is the finding
My lord,
of the appellate court judgment?
my lord. Page 51, my lord. If I
Yes.
may read again, my
Yes.
few lines. Learned trial court below did not discuss anything in regard to the part of cross-examination done upon DW1, namely Sahabuddin, because in his cross-examination, he admitted that in a Samajnama which was conducted by the public at large, he assured that he will not obstruct the appellant in regard to his possession upon the suit land. So that finding is perverse. Ma'am.
Where is your chief examination?
If, my lord.
No, no, may not be required. There's a clear finding that in his cross-examination.
Cross-examination, correct.
Okay. Heard. Three. J. Mukit. Jed Mukit, learned counsel for the appellant, who has preferred this appeal against the judgment of the judgment and decree dated 17/3/2023 of the first appellate court, namely the learned court of the civil judge Kamadarang, in title appeal number 8 of 2022, by which there was a reversal of the judgment and decree dated 15/6/2022, caused by the learned Munsif number 1, Darang, in TS number 147 of 2013. Full stop. The appellant was the defendant in the suit, which was initially dismissed by the learned Munsif, which and the said order of dismissal has been reversed by the first appellate court. The appeal is admitted on the following substantial question of law. You suggest 5.
5, my
I don't think it will. Okay, at page 8, no? Number 1. And we'll formulate the other one
lord.
regarding the appreciation. Whether the first appellate court was correct in appreciating the evidence of DW1,
Right.
but more specifically, the position made in the cross-examination pertaining to any compromise in Amel let steps be taken for service of notice upon the respondents by usual process as well as by registered post PTAD. Para, steps within 2 days. You're praying for some stay.
My lord,
Stay for what?
my lord, since the decree is for to recover the possession, my lord, I am possessing the land.
Where is the recovery part? They have not said that they are dispossessed.
My lord, but the decree is there, my lord.
Let us see the degree. That was what we are trying to understand.
Appellate court decree, my lord.
Where? Read.
Uh, my lord, page number 59.
There is one line, appellants are considered to have possessory title in view of continuous possession. Respondents are absolutely no right to dispossess the appellant, and it is directed that past possession of the absolute land is to be restored. Is to be restored.
Yes, that is what.
Third,
For that,
advocate counsel for the applicant who has filed this application under Order 41 Rule 5, read with Section 151 of the CPC for stay of the operation of the judgment dated 17/3 and declared so and so by so and so. The applicant has been admitted today by framing substantial questions of law. The learned counsel submits that if the impugned judgment is not paid, irreparable loss and injury may be suffered, would be suffered, and there is a prima facie case in their favor, as the impugned decree has been passed on a wrong appreciation of the materials on record, including the evidence of the para. After consideration of the submissions and taking into account the facts and circumstances of the case, it is directed that till the disposal of the appeal, which has been addressed, and circumstances of the case, it is directed that till the disposal. Yes.
Definitely, Your Lordship. One current finding is against me because I failed in the trial court as well as in the appellate. But at first, I want to submit before Lordship about the facts of the case, because if the facts is understood, then the law would be clear. Now, my lord, the appellant's husband, Forgestor Rabha, and his brother,
What is your name, Padmini?
yes, my lord,
Your name is Padmini Roy. Padmini Rabha.
Rabha and Jona Rabha. Appellant's predecessor, Horeshwar Rabha,
Forgeswar Rabha.
no,
Horeshwar.
Horeshwar Rabha, and Khorgeshwar Rabha were own brothers. And the land is situated at Udalbanga. Now it is coming within the municipal corporation. Earlier it was the Gedi land. That Horeshwar Rabha and Khorgeshwar Rabha obtained Khotian in the settlement operation of 1957-64. And thereafter, in the tenancy settlement operation of 1975, they also got the Khotian. Of course, Khorgeshwar Rabha was then died. Only Horeshwar Rabha was lived, and as such Khotian was issued to the name of Horeshwar Rabha and to the names of two sons of Khorgeshwar. So it is an admitted position that the land involved in the case is the tenant right. Now what happens, my lord, the landlord somehow with the help of some person got a deed of relinquishment of right executed in between the landlord and Padmini Rabha and the sons of Khorgeshwar Rabha, that is Jona Rabha and Kanu Rabha. Now, in this, that by virtue of that deed of relinquishment of right, whether the ownership right, whether my first submission before your lordship, whether a deed of relinquishment of right can be executed in between the landlord and tenant. I beg to submit your lordship attention to section 63 of the Assam Temporary Settled Areas Tenancy.
71 Act.
Yes, my lord. In that
First,
act,
let us see the relinquishment deed. Let us see the relinquishment deed.
that relinquishment of deed
Where is it? Let us see.
only tenancy by this relinquishment of deed, the landlord took away 3 bighas land, only 1 bigha land was.
Now, where is the relinquishment? Let us see, have a look.
Yes, 106.
106.
It was originally written in Assamese, and the Assamese deed is also enclosed there.
Okay, then what happened? Thereafter, what happened?
Thereafter, the plaintiff respondent encroached upon my land on the strength of a building allegedly executed by one Bolai Chandra Bhumi.
Now, aren't you the plaintiff?
No, my lord, I was defendant because when my land was encroached, then I dropped a proceeding under section 145 CRDC. In connection with that 145 CRDC case, the land was attacked. And thereafter, the 3 persons.
Padmini Rabha and another. In title suit, the Padmini is the plaintiff.
No, my lord. Padmini is not plaintiff. One here.
Where is the title suit?
Page number
Page number 14.
40.
14. 1 4. There should, under section 34 and 39 of the specific related. And in their prayer portion, a decree declaring that the plaintiff has right, title, interest over this footland. Now, this is important, my lord, because on the strength of a deed of relinquishment of right, no ownership right is transferred. Because the landlord executed the deed only to take away my land. So there is only transaction as regards the surrender of tenancy right and keeping of tenancy right.
No, see, in the relinquishment, it was not by Bidhan Roy, it was by the landlord.
By landlord.
Asad Ali.
Asad Ali.
Asad Ali says that out of the total area under your possession, he will give you an area of 1/4 of the land, that is 1 bigha.
1 bigha.
And you have to relinquish
1 bigha
the possession about the rest of the area, namely 3 bigha 18 lechas, isn't it?
Yes,
now, how is it connected with the suit, subject matter of the suit?
No, my lord, the sale deed. By the sale deed, ownership right is transferred.
Now, who sold it? Who has bought? Bidhan Roy has purchased the
Bidhan
property.
Roy is a purchaser
From whom?
from Bolai Nandi.
Who is Bolai?
Bolai Nandi also one of the persons who alleged to have purchased from Suna and Kanu Rabha. But Suna Rabha and Kanu Rabha were not examined as a witness in this case. Suna and Kanu Rabha are the sons of Forester Rabha. No, sons of Forester Rabha. They are also tenants.
Now, why was the suit initially filed by Bidhan Roy
Bidhan Roy
against
filed
you?
a suit because of the fact when they have encroached into my land, then I dropped a proceeding under section 145 and the police attached the land. And to stall the proceeding of 145, the Bidhan Roy, Samuel Roy, and Omiyanandi, 3 persons filed 3 suits separately. So my submission before your lordship that their prayer is for declaration of right title interest. So the plaintiff is to prove his case. The plaintiff is to prove that he has got the right title interest. The learned court will hold here that in settlement operation, they got mutation. So on the strength of that mutation, they cannot get the ownership right because by virtue of relinquishment of deed, only arrangement was made as regards the tenanted land. No ownership of the land was transferred. The landlord never executed this will. Only he executed the deed of relinquishment. So by virtue of that relinquishment of deed, no ownership right is transferred. because under the Assam Temporarily Settled Areas Tenancy Act, there is a provision under section 23. The tenant can acquire the ownership right by filing a petition before the Deputy Commissioner. So these things are not done. And more particularly, the tenancy was with the land of Horeshwar Rabha. Horeshwar Rabha died, 3 daughters, 2 sons. Only Padmini Rabha was arranged as a part to the deed of relinquishment of property. So Learned Court below, only basing upon the mutation and the sale deed, passed the judgment in their favor. But it was overlooked whether the plaintiff acquired the ownership right, because they could not acquire the ownership right by virtue of such a deed. Now, another submission before your lordship that the Learned Appellate Court in the judgment have not formulated the point basing upon which the appeal judgment of the appeal was passed. So the mandatory provision of law under Order 43, Rule 31 have also been violated in this case. My substantial question of law in this case, whether the landlord could execute a deed of relinquishing his ownership right in favor of the tenant to get the land tenancy surrendered by the tenant. Because under section 63, it is very much clear, Your Honor, if the tenant do not like to keep his land, my lord, then he can surrender to the Deputy Commissioner. But he cannot surrender the land.
But we are failing to understand, this is not a suit with your landlord. One is Vidhan Roy has filed.
Yes,
How did he come to the picture?
Vidhan Roy has come to the picture because on the strength of relinquishment of deed of right, Sona Rabha, it is arrest. Actually, whether the deed was executed by Sona Rabha or not is not known because they could not produce them as a witness. That Sona Rabha and Kanu Rabha executed sale deed in favor of Milan Chakraborty and Bolai Bhomik in the year 1995, and in the year 2007, that Bolai Bhomik and Milan Chakraborty executed those sale deeds. So, my another submission before your lordship, whether a tenant without acquiring the ownership right under section 23 of Assam Temporarily Settled Areas Tenancy Act could execute sale deed under void and invalid deed of relinquishment of right. Now, my lord, the tenant under section 8 of the Assam Temporarily Settled Areas Tenancy Act can transfer land, but to whom they can transfer? With the permission to the other agriculture.
Let us see the first trial court judgment.
These things were not discussed.
Let us see the trial court judgment.
Page 67.
Page 67. 5 numbers of issues were framed by the trial court, my lord. One, whether the suit is maintainable in present form and law and fact, whether the plaintiff has right title, interest, as well as possession over the suit. This issue was not properly discussed, not only by the learned trial court, but by the appellate court also. Because the plaintiff could not prove the fact that the ownership right was transferred.
Where are your substantial questions? We're finding difficulty here. Have you framed the substantial questions of law?
I have submitted as many as 6 numbers of substances.
Page
At page 11.
11. Yes.
Whether the landlord could execute a deed of relinquishment with ownership right in favor of the tenant to get the land of tenancy surrendered by the tenant. So this is clear, my lord. Under section 63, the tenant cannot surrender any land to the landlord. Whether the landlord could transfer his ownership right in favor of the tenant by executing a deed under the name of relinquishment of right. So by virtue of a so-called deed of relinquishment of right, no ownership right has been transferred to the tenant, and so the tenant could not transfer any land. Whether the plaintiff respondent could claim to have got the right title interest in the suit land on the basis of illegal entry of his name in the Jamabandi record. They have the influencing over the settlement authority. They have mutated judgment. But as a matter of fact, the tenant's name was not mutated because they claim to have purchased the land from Sonarapa and Kanurapa. But the mutation is not their name of Sonarapa and Kanurapa were not mutated. Whether the-
Are you denying the relinquishment deed? Denying.
I am not denying, my lord, but I am saying that it is illegal. By virtue of that deed, no ownership.
Then how can number one be a substantial question of law? Whether the landlord could execute a deed relinquishing.
Landlord cannot execute because landlord cannot take back the land from the tenant. Because under section 63, tenant also cannot surrender land to the landlord. If
No,
at all-
unless you took the provisions of 1971 Act into. unless you file necessary application under section 23 of the 1971 Act,
Yes, my lord.
and your rights are recognized. Till that time, there was no such proceeding of under 71 Act.
Yes.
Was there a proceeding?
No, my lord, there is no such procedure.
Then simply by a tenant without invoking the 71 Act, right is not automatic.
No.
It is to be conferred.
What I want to submit before your lordship, under section 23. under
Yes.
23, tenant can make an application.
Right.
If he does not make any application, then what would be his position?
Yes.
His position would be that of a tenant.
Yes.
His position cannot be interfered. He cannot transfer any land because under section 8 of the Assam Control and Settlement Area Financial, tenant also cannot transfer the land.
No, there has to be a finding that you are a tenant. There is no such finding.
They have submitted the Kotian. I have got the Kotian also.
But the dispute is not essentially between you and the landlord. There is one third party, Bidhan Roy or some Roy. He is the plaintiff.
Yes, he is plaintiff, but he claims to have purchased the land to some person who
Just a minute.
hasn't to have purchased the.
Was there any recognition that you were a tenant by any court of law or by any authority?
Because my predecessor obtained Kotian.
Kotian was exhibited in the suit.
Yes, madam. I have
Exhibit what?
I have exhibited those documents.
Exhibit what?
As GW. This is the Kotian, this is the public document, my lord. I have exhibited those documents.
Exhibit
And
and
they have also, along with the claim, they have submitted this, that Padmini Rabha had got tenancy right. They have also stated. In their claim, my lord, their claim may kindly be perused. Some claim from me. At paragraph number 3 in their claim, my lord, at page 16, that in the aforesaid land, 3 persons, namely Horeshwar Rabha, Kanu Rabha, and Sama alias Sona Rabha, were the recorded tenants. So this is the admitted fact, my lord. Admitted aforesaid 3 tenants for the period of 1957-68, they have admitted that my predecessor was holding the land as a tenant since 1957-64. And also in the year 1975. Thereafter, a new Kotian number 56 was reissued to the Kotiandar tenant on 28/5/1993. So they have admitted all this.
This relinquishment deed was registered.
Yes,
It was registered.
Registered. Because my submission that though it is a registered one, it has got no validity in the eye of the law. only relinquishment of
Aren't you
rights.
required to have a declaration?
Only relinquishment of rights, so far my knowledge is concerned, can be executed amongst the co-sharers. But here it is, Padmini Rabha is not a co-sharer. The landlord Potadar is Mir Asad Ali and Padmini Rabha is a tenant. So there cannot be.
Then, but the vendor of Roy was one Milan Chakraborty, isn't it?
Milan Chakraborty.
Milan Chakraborty.
He has executed the deed by a attorney holder. He is not coming forward to support the fact that he got the possession of the land and he has been holding the land. These things were not true. All these things were not appreciated by the court below in their judgment. So only basing upon the fact that they got their mutation in the settlement operation. So whether this, I have argued on this point, but
unless there is an order under the 71 Act, where does your right, from where do you accrue your right?
I accrue right, my lord.
There is a Khatian, no doubt, there is a Khatian.
I accrue right.
But being the Khatian holder as a Rayat, you have to get your rights recognized under the 71 Act. There was no such recognition.
Yes, this two Khatians. They have
No, Khatian is there. You are a Khatian holder.
No, my
Simply by
lord,
Khatian holder will not give you the right.
my lord, frankly, in the frame, in paragraph number 3, that the aforesaid land three persons, namely Horeshwar Rabha, Anu Rabha, Sana Rabha, and Puna Rabha, the area Puna Rabha, were the recorded tenants.
Yes.
Under the landlord Asad, as they were cultivating the land. So it is admitted that Horeshwar Rabha was cultivating the land.
There is no dispute to the fact that you are a Khatian holder tenant.
Yeah.
But was your rights recognized under the 71 Act? Did you invoke the 71 Act, file an application?
My lord, I have not any application.
In that case,
No, I have got the possessory right then. I have got the possessory right.
so 71 Act
That is-
also.
Now, in the meantime, your lordship may kindly, please section 23.
23 and we says that you should make an application before the deputy commissioner. He will issue notice to the landlord. There will be a proceeding. Then your rights should be recognized. You have not.
No, my lord, acquisition of ownership right and intermediary right by tenants. Any occupancy tenant personally cultivating the land of his tenancy desirous of acquiring the ownership right of the landlord may at any time make an application.
Yes.
At any
There is
time.
an obligation for you to make an application.
Yes,
Where is that application?
I have not filed it.
Then in that case, where is the right?
But still my tenancy right has not been forfeited, my lord.
No, unless it is recognized by the 71 Act. In a
No,
proceeding under the
71
71 Act.
71 Act is very much clear, your lordship, that by virtue of section 23, ownership can be acquired by filing a petition to the deputy commissioner.
Yes.
If I do not file, whether my tenancy right would be forfeited? No, my lord, my tenancy right will not be forfeited. That is why, at any time.
You have not challenged the deed of relinquishment. There is no counterclaim.
Not misrepresenting me that deed was executed.
You should file for a declaration that the deed has been executed without your consent.
No, my lord.
At least that as a counterclaim, you should have raised that issue.
No, they have not denied the fact that I was a tenant. Had there been a denial, then I would have filed the counterclaim.
No,
But in
there is
their
a
claim-
relinquishment deed. Rightly or wrongly, there is a registered deed of relinquishment.
Yes.
You have not put that to challenge. You have not challenged it in a counterclaim also. No separate suit. You should have, they are missing their entire claim on the relinquishment deed, which is registered.
Now, my lord, so it is to consider the law. what is the law? That a deed of relinquishment of right could be made amongst the co-owners. Who share right?
Have you raised that question? The court will decide when somebody raises the question.
I have raised all this.
Where? Where is your claim? Where is your counterclaim?
I have not made any counterclaim,
Then,
but in my WS I have raised it.
WS, you are defending your case.
Yes, my lord. That is.
As a defendant in a WS, your role is a very limited one. Unless you make an independent prayer by means of a counterclaim,
No, my
challenging the deed of relinquishment, how can the court
lord.
say
In my
on its own?
Opinion, I am not at all necessary to file a counterclaim, because my case is very much clear that they have got no right, but I have got possession. But they have entered into my encroached into my possession. So I have filed a case, 145 case, and they have filed a civil suit. But in that civil suit, two things.
You know
are
the
there.
limited
There are
role.
plenty
You know the limited role of a 145 proceeding. 145, the role is very limited of the magistrate. It is ultimately the civil court which will
That
decide.
is why the 145 case was stayed by the executive magistrate as the civil suit was filed. But my submission before your lordship, whether the so-called transfer have got any ownership right, because by virtue of SLD, ownership right is transferred.
See, the questions
By
which you are
virtue of
raising,
SLD,
questions which you are now raising are legitimate questions, but you have not raised in the appropriate stage. You are the defendant in the suit. You did not file any counterclaim. You just filed your written statement. Now you are saying that the deed of relinquishment is not, has to be declared as illegal.
No, Lord, in my humble opinion, that the plaintiff is to prove his case.
Plaintiff has a registered deed of relinquishment.
Yes, by this deed of relinquishment of right, no ownership right is transferred by virtue of subsidy. That is why this is the substantial question of law, my lord.
We have difficulty in agreeing with you in this position. If there were certain acts, you did not invoke 71 Act, number 1. You did not challenge the relinquishment deed.
No, I do not challenge that.
You say that there is a Khatian in your favor. Yes, there is a Khatian.
I
But you have no, you should invoke.
Because what the Khatian indicates that I have got position. I have got position. And if somebody entered and goes into my position, then he must prove the fact of his better title.
It is not a question of enforcement. There is a registered deed,
No,
which
no,
is switched
there
till now.
may be registered deed, that there may be so many packages are there. So many packages are there. But
It has to be
whether-
declared fake.
No, my lord.
By simply saying fake will not do.
My lord.
Some court of law will have to say that it's a fake deed. It is not operative in law.
My
You
lord,
may have a good case, but you have not agitated your rights
my lord,
in the proper forum, in the manner required.
that one thing is that the ownership right. is-
No, you may be correct in your proposition, but there has to be a declaration that the relinquishment deed is inoperative, illegal. You have not been paid for. It's a registered deed after all.
That may be, but the purpose of the deed is to be looked into your lordship. The purpose is to take away land from me.
You have not availed your right now in the
Transferring
second
the
appellate
ownership
stage.
right.
We will not be able to help you, I think.
Had there been a sale deed transferring the land to me, then it's not the case.
Let us have it on another day. We are not too satisfied. We don't want to dismiss this matter. Let us see. We'll have it next week. Date convenient to you. Tell us.
In this month or.
Whenever. Huh? Put it.
continuously হয়েছে একদম still sound হয় whistle no no still sound এখন yes tell us a date whenever 3rd of August 4th of August 3rd is a Thursday 11 and 4th of August though this matter was heard at some length, this court is of the opinion that to examine whether there is any substantial question of law, some more hearing would be required. List as requested, list on 4th of August. You can take this back. Yes, Mr. Aluda, what is this? Second appeal.
Second. May please, your lordship. In this case, actually, wrong forum of the file this case, originally. It is an agreement is made between the plaintiff and the defendant on Your Honor, may.
You are the defendant.
No, I'm the defendant. Actually, what happened? An agreement is made for purchasing a plot of land. My plot of the land still kept for him. Still,
You're the owner.
yeah, I'm the owner. But if this plot is situated at a good locality, the 2 quarters of land, I'm owner and possessor. 1 and 5 quarters, I'm going to be sell due to urgent need of money.
You have 2 kathas of land.
No, 2 quarters.
Out of 2 kathas, you want to sell 1.5 katha.
No, 1 quarter 5. 1 quarter 5 years.
1 K 5 L.
1 quarter 5 years. Right. Land is free for all incumbencies.
Okay.
Still is kept for him.
Okay.
What happened actually? They made agreement, received the 2 lakhs of rupees. It is a valid receipt. They filed a case, money suit for 5 lakhs. What happened? Initially, after agreement, 1 year we issued a legal notice to complete the sale. Otherwise, your money will be forfeited. No.
How much was the advance amount?
2 lakhs. They filed money suit for 5 lakhs. Now, what happens? He's an honest person. What happened for the?
Why didn't you make the sale deed? What prevented you? Why was the sale deed not executed?
No, not executed.
Why?
not they are participate for cell transaction power permission, they are not cooperative. So we issued a legal notice to them. They not cooperative. What happened? It is a very interesting. They filed a criminal case against me. Then he arrested. Thereafter, after hearing of the additional chief judicial magistrate filed a criminal case. After hearing, this appellant is discharged. Second mistake is they filed a money suit for 5 lakhs. Your Honor, Your Honor, the concurrent view, money suit and the title. In the trial court, we file a petition for paying up the so whether the suit is maintainable or not at all considered. Against the appellate court, under the provision of Order 41, Rule 25, file a petition to frame the additional issue whether the suit is maintainable. That is also not considered. That is that.
You raised the maintainability issue in this the WS.
Yes.
You had raised in the WS the maintainability issue. That was not, no issue was framed.
No, that is it. No, that is the problem.
Now there is a decree against you
The decree against you
for 5 lakhs.
for 5 lakhs. Hey, Your Honor, my substantial question is this. Whether the judgment of the learned
Page. Where have you formulated? Where have you formulated? Yes.
Whether the judgment of the learned first appellate court is vitiated due to the perversity of the reasoning and due to the surmise of the misreading, the misconception and misinterpretation of the materials on the record.
This is not a substantial question.
Your Lordship, what a very important issue, whether the suit is not filed in a proper forum of the law, as are the liable to the dispute, not proper forum, as per the specific relief. It is a specific relief case.
Let us see the plain. What was the relief claim?
Relief. Your Lordship.
Let us see the plain.
Plain.
It's a money suit.
Money suit. 12 to 19. 12 to 19. That's in the
Suit for realization. They have not paid for a declaration.
the suit for realization is valued rupees 5 lakhs. 5 lakhs for
They have not
the
paid for any specific performance.
the case is a specific as per my agreement. Your Lordship. Specific relief act. Specific.
They have not paid for specific performance of the contract.
No.
They have only paid for refund of the money. They are the plaintiff, dominus litis. They can, they're right. How do you present the suit?
I am received the only 2 lakhs. They filed for 5 lakhs.
That is your contention.
Another defect of the plaintiff, Your Lordship, there is High Court specific direction. There is no any what provision this case is, this suit is filed.
Mr. Talukdar, come to page 17, the relief. They have not paid for 5 lakhs. They paid for 2 lakhs and 2 lakhs for compensation.
Actually, I should get compensation. I am victimized.
Why didn't you file a counterclaim? Why didn't you file a counterclaim or a suit, independent suit?
No, I filed the written statement.
Written statement will not do. In a written statement, can relief be given to you? Come to 17, they have only paid for 2 lakhs.
2 lakhs.
Degree for refund of 2 lakhs and additionally 2 lakhs as compensation.
Compensation.
So what is the difficulty? You have contested.
Yeah, Your Honor, this suit, this file, what provision is this suit?
It's a money suit.
Money suit, there is no order. Order 7. There is specifically the money suit, where the plaintiff seeks the necessary recovery money, the plaintiff shall state the precise amount claimed precise amount, there is no any provision. Under what provision CPC 5? There is no any provision.
That is not required. Is it required?
Eh, when a
Is
case,
is there a difficulty in understanding what is the relief paid for?
no, actually, when a
If he
case
has
is-
paid the court fee, if he has fulfilled all the other requirements,
there is specific circular also from the High Court. When a case is registered, there should be specific. Every case,
that is not a substantial question. Come to a substantial question.
not substantial question of the law.
It is not going to help you.
Substan-
We don't think there is any substantial questions of law involved.
the- Whether the suit for specific performance of control
This
may
is
be
not a
treated
suit
as a
for
money suit.
This is not a suit for specific. They are not seeking specific performance of the contract. They want their money back.
Or the money back, what basis? As per the agreement, sale for specific matter of the specific performance, not for.
They
for
are
the
not.
money suit.
They are not interested in with the contract. They want their money back. This court has ruled in their favor. Both the court. You are admitting that you took 2 lakh of rupees. You should have returned.
No, I am not admitting 2 lakhs. I am admitting 2 lakhs. There is a receipt, money receipt. Why they filed for 5 lakhs?
They have paid for compensation of 2 lakh. Amount claimed is only 2 lakhs. Compensation is 2 lakh. You should have compromised if you are a bona fide, if you have bona fide intention.
Now, Your Honor, in the evidence in record, nowhere stated whether it is a money suit or whether I mean money lending method, nothing, nowhere any mention, no any evidence.
You cannot be a money lender. You to be a money lender, you have to,
Money lending.
you have to have a license under the act. You cannot lend money like this.
Another subject, whether without a cause of action and order 7 rule 2 of the Code of Civil 1908, money suit is maintainable. There is not specific. And the plaint is not specific.
It has been proved that 2 lakhs of rupees was taken by a deed of agreement. The sale did not occur. They want their money back. The suit has been decreed with compensation of 2 lakhs. Difficult.
This substantial issue, whether the suit for specific performance may be treated as a money suit.
Again, you are repeating. They have they paid for specific performance?
Specific performance,
Have they paid for specific performance?
yes, ma'am.
Have they paid for? See the relief. Come to the plaint. You have annexed the plaint at page 17.
17. Plaintiff therefore may following the relief. A decree for direction for the defendant to may pay the
Amount of rupees 2 lakhs.
2 lakhs.
Against the sale agreement as advance consideration. Decree for direction of defendant to pay compensation of 2 lakhs.
2 lakhs.
Decree of direction to pay amount of interest at 18%.
88 per annum.
Full cost.
Like,
There
for
is no
execution
prayer
of
for
sale agreement.
there is no prayer for specific performance. It is up to them whether they pray for specific performance, whether they want their money back. Difficult case, Mr. Talukdar. Unfortunately, we have to dismiss this. And as you know, second appellate, our role is very, very circumscribed,
No,
limited
Your
role.
Lordship, it is
There is no substantial questions of law involved.
substantial specific performance of this. As per the contents of the agreement, matter is a specific performance of the con. Your Lordship, specific performance. Now, whether the suit for specific purpose of control may be treated as a money suit.
That has not been treated as a money suit, it has been filed as a money suit. They want their money back, simple.
the plaintiff is not interested in specific performance. Basic है क्या तो comment. These are statement in paragraph 5, page 14.
Page 14.
They were offering the rest of the balance amount. You had refused to accept.
No, my lord.
That is the averment in the plaint. We do not know what is the truth. Truth has been extracted in the trial. It's a part of the judgment. This agreement was dated when?
13/4.
August 2014. Good.
Even 35/2014.
And the suit was instituted in 16. Their allegation is that you have denied to go ahead with the execution of the sale deed.
No, my lord. Still, my land is still intact. 1 quarter 5 less. They are not fully cooperative for obtaining the land sale permission. That is the matter.
You had issued legal notice.
Legal notice. Page 11 to 16.
Where is the legal notice? Let us have a look.
11, page 11.
No, legal notice. Legal notice which you have referred in your written statement. That you have issued a legal notice asking them to complete the formality of the sale deed.
No, you're in the IA. IA.
Page,
Page 11 to 16.
where is the reference to the criminal case?
8 to 10. For photocopy of the edition, 8 to 10.
In the
IA.
difficult, Mr. Talukar.
Your Honor, I am playing for another day regarding the specific performance. My substantial order the suit for specific performance may be created as a manuscript.
You have seen the suit, you have seen the plane. It is not for specific performance, it is for refund of an amount. They are not interested in the contract of the sale of the plot of land. They want their money back.
Last 1, 2, 3 years, they are not cooperated. The agreement is made.
It was up to you to adduce evidence to show that you You were ready and willing to pay, have the sale executed. They did not come forward.
But I am facing the difficulties for this agreement.
Did you adduce the evidence in the trial court?
Yes, ma'am.
How many witnesses?
It is not, the witnesses, 4 witnesses. 4. No.
From your side?
Yes. Now, each and everybody is admitted that it is not a money lending matter.
It cannot be a money lending matter. Nobody can lend money. It's prohibited. Unless, of course, you have a license.
Your Lordship, I am facing the difficulty after making it still the land is kept for.
You sell this land at a higher amount, give this amount to the
Now it is
plaintiff.
now it is your Lordship, it is available near airport.
Then it is better for you.
Now
Your consideration was only 12 lakhs. You have to pay 5 lakhs to him. You say sell at 20 lakhs now.
no, one case is running. One case is running, we are afraid of the.
Not afraid. Is there any injunction? You sell the land to some other party. From the sale proceeds, you pay the amount. There is no injunction. It's your land. They are not interested in buying the land. They want their money back. There is an order of the court to give their money back. Land is free.
Your Lordship, as per the provision, it is not a money sheet is not mandated. But so I am showing the provision. Another that your Lordship make anything.
You may have another date, but our opinion will still be the same. Okay, we'll have it another day. You try to convince us to have another view. As on the prayer of Sri M. Talukdar, counsel for the appellant, list after a week.
Must.
Yes. Yes, 14, 15. None appears for the parties. Appellant on call. On the last occasion also, that is 28/6/2023, none had appeared, and this court had made the following observation. In view of in view of the above aforesaid facts and circumstances, no, this court has however noticed that after framing of the substantial question of law on 5/5/2008, this matter was discussed for the first time on 28/6/2023. This court is also aware of the fact that G.P. Bhomik, who was the learned counsel for the appellant, has passed away. In view of the above and in the interest of justice, let this matter be listed again after a week to give another opportunity. If you want to listen, huh? I think, after, no? I think it's there. No, don't confirm. Don't ask anybody. It will be very embarrassing. I don't think. But who passed away then? His daughter passed away. But he doesn't come to the court nowadays, I think. don't write down. This court has also noticed that Sri G.P. Bhumik was the counsel in this case, is not very active. Court of Dalpatli, huh? Next week, very quick. If the situation, if the same situation however persists, this court would be constrained to pass appropriate orders. Yes. Next. Experience.
May I please, Your Lordship? Matter may be for the adjourn for the day, my lord.
Here for the appellant.
Yes, my lord. My senior has personal difficulties, my lord.
On a prayer made on behalf of the appellant. This is 2008 matter.
Yes, my lord.
Matter, on a matter is adjourned. Also, however, considering that this appeal of the ease of the year 2008, list on Monday next.
I love.
Yes, Mr. Bonik.
My lord, there's an order, 23rd of March 23. What had happened is that, the both sides counsels either got elevated or they were in judicial service and the respondent sides were not appearing. And in this view of the matter, that order was passed to send the report, that the report has not come back, I presume.
What report?
From the respondent side, the
Given
registry
service
was,
of notice on the respondent.
my lord.
This is 19. You take fresh steps.
No, there will be another difficulty. Difficulty is that, I know for certain that my client is no more because he was a practicing lawyer also in the High Court. But when I contacted the family, they respond and they hold back. So possibly I'll issue a letter to my client, not to the other side. It was a landlord tenant dispute possibly settled up long back. I don't know whether the gentleman is also alive or not.
The appellant was a practicing advocate.
Yes.
Prakash Kumar Bhurwar.
Yes, yes.
Not being able to recollect.
So I know for certain that he is no more. But the family members are not cooperating with me, possibly on the ground that this is a dispute was with the tenancy dispute area, and this was concerning a money suit, and the appellate authority.
Oh, he's from Tinsukia.
Yes. And the appellate authority was directed for remand of the matter. So I do not know.
If they're not interested, then
That's-
you write to them and
I'll write to my client on the
we'll
death-
close it. Thereafter we'll close it. You write.
on the abatement ground only it can be closed. That's what I'm.
Oh.
Lordship may not record that.
No, Hartsley as Bonik learned counsel for the appellant who submits
That the report is not.
that he has to take instructions on the future course of action.
Lordship.
Full stop. Para. List after 10 days.
It should be slightly after 4 weeks because I'll write to them by registered post at the address so available with me.
Phone numbers are not there.
One phone number was there that some lady claiming to be the daughter had called. I do not vouch for these identities.
List after 4 weeks to enable obtaining of instruction. Whereafter the matter would be taken up
Lordship.
for consideration.
Obliged.
May it pleases your lordship, in this case, LCR has been received, matter may be fixed for hearing, lord.
Questions framed.
Yes, lordship,
Which order?
lordship,
By which order questions have been framed?
that I am.
Substantive questions of law, framed or not?
Lordship, it was admitted long before, lordship.
What is your prayer now?
Lordship, it may be fixed for hearing, the main appellant number 1 had
It is
expired.
submitted
Accordingly, we
that this appeal has been admitted and LCR which were called for have been received. LCR received? Put the para. Please for why order? Served or not?
service is complete, Lordship.
Please for hearing. In its in due course. On its turn. On its turn. 17th matter will come. Yes, next.
Obliged.
May I plead your lordship? Lordship, steps has been taken upon respondent number 9 and 10. Also, newspaper publication has been made, but nobody has appeared for respondent number.
Have you
9.
filed the affidavit with
Yes,
the
Lordship.
newspaper? You have not filed affidavit.
Lordship, affidavit has been filed.
Filed. Yes. Your name?
G. Das.
G. Das, Learned Counsel for the appellant submits that so far as service of notice upon the respondent numbers 9 and 10 are concerned, comma, that has been done. That has been done by paper publication in terms of the earlier order of this court dated 30/5/2023. Full stop. The Learned Counsel has also submitted that consequent thereto, comma, an affidavit has been filed on 26/6/2023, annexing the newspaper, which is perused. Put the para. The service being complete, comma, registry release this case for hearing in its turn.
May I plead your lordship? My lord, by order dated 26/2023, lordship, we are directed to file an application, lordship, for taking steps to paper publication. Accordingly, we have filed an application, lordship, being IN number 1885/20.
You have taken these steps.
No, lordship, we have filed this application for granting leave by this honorable for taking steps to paper publication. We are seeking leave now.
The opinion that has to remain. You have filed in IA.
Yes.
IA is
We are
before
directed
us.
to file.
IA is there
Yes,
before us.
yes.
Heard MS M. Chaudhary, Learned Counsel for the applicant appellant. You are for whom? You are for
Respondent 1, 2, and 3.
who has filed this application for grant of leave for service of notice upon the respondent number 4 and 5 by substituted method in the form of paper publication. They come from which place?
From one is from Nagaland, that is respond number 5, and 4 is from Kohima, lordship. We pay to take steps. To Times of India is paper, lordship, we can take steps.
4 and 5,
Yes.
both from Nagaland.
One from Nagaland.
Both
Yes,
from
yes, yes,
Nagaland.
both from Nagaland, yes.
How do you, which paper will you prefer?
This is lordship, Telegram or it's or Times of India, lordship, because will widely distributed all over India.
Uh, upon consideration of the prayer, comma, paper publication, a service of notice upon the respondent numbers 4 and 5 by paper publication is allowed, full stop. As suggested, comma, such publication can be made either in the Times of India
Lordship.
or the Telegraph. Which, as those are national dailies having circulation all over the country, including the state of Nagaland, from which the respondent was 4 and 5. State of Nagaland, having the addresses of the respondent was 4 and 5. Full stop. Let such publication be done within a period of 3 weeks from today. Is it?
6 weeks, Lordship, because the text procedure is there. Lordship.
No, 3 weeks, then we'll fix another date.
For a
3 weeks, 3 weeks from today,
Lordship.
and the matter may be listed for listed in the last week of August 2023. Oh no, don't say it last week, on 30th of August, 30th of August 2023. Full stop. Before the same date, comma, the appellant is required to file an affidavit to bring on record the said publication.
Please, your lordship. Appeal has already been admitted. LCR also received. My learned friend is appearing for
all the
respondents.
All the respondents.
Let the matter be posted for hearing.
It is seen that the contesting respondents have entered appearance and the LCR has also been received. Full stop. Registry to release this case for hearing in its turn.
In this case, respondent number 1, 2, 3, and 4 has appeared, Lordship. Respondent number 5.
On that for whom?
1, 2, and 3, your lordship.
And respondent number 5 is the driver. Lordship, my prayer is that his name may be strike out. Lordship.
And madam,
Respondent number 4.
who's for?
Who is the owner?
Owner is also there. You want to strike off the name of the driver?
Lordship.
No. Heard Sri K.K. Bhatta, learned counsel for the appellant. Why application has been filed?
Delay application. Condonation of delay.
Notice issued or not?
Notice.
Delay has been condoned.
No, delay has not been condoned.
Oh, we filed,
I pay for 2 weeks extension.
we'll file objection.
Yeah.
And
I have already filed.
Yes.
K.K. Bhatta, counsel for the applicant. Full stop. Where Sri Mondal has appeared for respondent numbers 1, 2, and 3. Madam, your name?
Miss Das. Miss Das. Ardas.
Ardas. MS Ardas has entered appearance for the respondent number 4. While Mondal has appeared for respondent number 1, 2, 3 and has filed affidavit and has filed objection. MS Ardas has appeared for respondent number 4 and has paid for 2 weeks time to file the objection. Full stop. So far as respondent number 5 is concerned, who is the driver, comma, Sri Bhatta, the learned counsel for the applicant, submits that his name can be struck off from the array of parties. Full stop. Para. Accordingly, the name of respondent number 4 is struck off.
Respondent 5.
5. 5. 4 to Mera.
Owner.
List after 4 weeks, at least after 2 weeks, along with the objection that may be filed.
Obliged.
There is a lapse from our side. We failed to take the step on in terms of the last order. We've already.
First steps you have not taken.
Lots. There is a lapse from our side.
Taken or not now?
I have already instructed lots. Within 2
Uh,
days, it will be taken.
Sri Didas, learned counsel for the applicant, submits
that due to inadvertence, steps could not be taken upon the respondent numbers 2F, 1G, and 14.
Yes, Lordship.
Full stop. He accordingly prays and is granted for the time of 2 days
Lordship.
to take the steps as directed in the mode directed by the order dated 14/12/2022.
Lordship.
Both processes there registered as a
Yes,
registered.
Lordship. I have already seen. And deeply aware.
What is his personal appearance?
No, personal appearance was directed as the respondent in the contempt petition. 26 is the contempt petition. What has happened is that the respondent refused to accept service in the contempt matter. Now, learned advocates have filed wakalatnama for him, and subsequently they withdrew. So Dhar is appearing for the government only in respect to the warrant.
We have no report.
But
I will just peruse the order dated 14/6/23 and 5/6/23.
Never seen.
So, my lord, what we did, we tried to, my lord, execute that available warrant. My lord, we have searched for the man, Babul Gogoi. My lord, I have a report now that placing it before us.
May you tell us?
That is that flag X, otherwise.
May you tell us? You make a submission.
The report,
You tell what is the report about?
the report says that, my lord, that in the name of Babul Gogoi and son of,
Kandhar,
no, my lord, in
son of Kandhar.
Konok Chandra Gogoi in the petition was
Konok is alias Kandhar. It is your competency of the officer.
No, my lord. This is the document my officer has received from.
Your officer will come to the court now.
My lord will just.
There is one Kandhar in the next village.
My lord will tell you what was supplied to us. My lord will.
What is supplied? The entire record is with you. The police officer cannot execute an available warrant of arrest.
My lord, we could not trace the man.
What cannot trace the man? What are you saying?
My lord will.
What are you saying, Mr. Dhar?
My lord, we go by the order, my lord.
You come to the report. Report also.
Flag X.
Yes, come to a report.
Yes, ma'am.
The inspector writes, he is Babul Kumar Medhi. He writes to the superintendent of police. You have got this report?
Yes, ma'am. Yes.
Read the third paragraph.
Further, an inquiry has been extended to other nearby villages to trace out the accused person in order to execute the warrant. It is known that a person in the name of Babul Gogoi is found at the village Kukurjan, ward number 4, under the case, who has been residing in the
Last 7 years.
7 years.
But his name, father's name is found to be late Kandhar Gogoi. Yes.
In support of this, government that is given. Now, my lord will just see the letter that was sent.
What is the name of Babul Gogoi's father?
Konok Chandra Gogoi, my lord.
What Konok Chandra Gogoi? Come to the area parties. Konok is Kandhar.
My lord,
You have the petition copy.
my lord, petition copy was not sent to the.
That is up to, he knows that Konok is Kandhar.
No, my lord, I will just peruse this registry letter, my lord. I have just placed it last page, my lord.
Mr. Ganguly, do you have the main petition? Just show him the area parties.
Yes, ma'am. I have.
My lord.
See, police officer knows everything, and this is the kind of report he is giving to the court.
My lord,
Ask him to come.
my lord will just.
Ask him to come.
My lord, I will.
Mr. Dhar, don't argue with the court.
My
Ask him to come.
It is not his fault, my lord.
We are going to interact with him.
Just.
We are going to interact with him. He's a police officer. They know everything.
Who's the father, who's the grandfather, who's the great grandfather, they know everything. Simple. The other village, they found that a person, this matter has been pending since so long, bailable warrant has been issued, and that is the attitude. You can't bring a person to the court.
I will just read the last page. I will
Heard.
executed manual. Just the last page.
Sorry. Heard 3A Ganguly, learned counsel for the petitioner. Also heard 3. Ardhar, learned additional senior government to get the sum. Full stop. Para. This court by order dated 12/4/2023 had issued a bailable warrant of arrest against the sole respondent, Sri Babul Gogoi, and had directed the Superintendent of Police, Sonitpur District, to get the warrant executed through the officer in charge, Gohapur Police Station. And the next date was fixed on 3/5/2023. Full stop. On 3/5/2023, there was a note of there were notes dated 2/5/2023 of the office and a communication dated 25/4/2023 of the SP Sonitpur, from which nothing was discernible regarding execution of the warrant. Also, the matter was accordingly directed to be listed again on 5/6/2023 and with a further direction to issue fresh bailable warrant of arrest. Full stop. On 5/6/2023, there was no development, and this court had again issued a fresh bailable warrant against the defendant, against the respondent. Full stop. When the matter had come up last on 14/6/2023, this court was informed that since a holiday was declared on the date fixed, another date should be given, and accordingly, this court had fixed today for today is the next date. Full stop. Sarah. There is a note of the office dated 17/7/2023, which refers to a report by the Superintendent of Police on the bailable warrant of arrest, which is also made a part of the record. Full stop. The forwarding letter dated 11/7/2023 by the Superintendent of Police, Vishwanath Chareli, has enclosed a letter by the inspector, by the officer in charge, Gohapur PS, dated 5/7/2023. Full stop. The said report states that in the local inquiry made, no person in the name of Babul Gogoi was found in the village, and a certificate of the Gaon Pradhan was also enclosed, was also referred. Full stop. Para. No, para. No. The report further states that enquiry was made in the nearby village, and it was known that a person in the name of Babul Gogoi exists in village Kukurjan, which in bracket ward number 4, whose father's name, however, was found to be late Kanadhar Gogoi, and a certificate of the Gao Pradhan of Kukurjan lot, along with a copy of the PAN card of Babul Gogoi, have also been referred. The explanation given is that in view of the anomalies in the address of the warranty, Babul Gogoi, the warrant could not be executed. Full stop. What astonishes this court is that though there may be certain anomalies in the name of the village, the name of the father of Babul Gogoi has been given in the appeal as son of late Kanak Chandra Gogoi, alias Kandhar Gogoi, and therefore there should not have been any difficulties in executing the warrant of arrest. Full stop. Para. Such mechanical approach by the officer in charge, Gopur Police Station, which also seems to be endorsed by the Superintendent of Police, Vishwanath, is not at all appreciated by this court. Full stop. This court was therefore inclined to have the matter personally explained by the officers concerned. Full stop. However, giving all benefit of doubt and doubts and in the interest of justice, a further opportunity is granted to the concerned officer to execute the warrant of arrest, the bailable warrant of arrest as issued by this court, as full stop. Such execution has to be done forthwith, as orders of this court cannot be treated in the manner as has been done in the instant case. Full stop. Place this case on on 2nd of August. 2nd of August. Full stop. Let a copy of this order. No, we will not give you a copy. You get a certificate copy.
I have to communicate further.
You communicate. Why should you give a copy? We wanted to invite them to the court. Only we have acceded to your request. You have not invited.
But there's an interim order in item 25 that status quo.
26.
25. 26 is the contempt.
No, 25 is the contempt.
Oh, I'm sorry. Then 26.
In 26, the connected contempt case has been directed to be listed on 2nd of August. Full stop. Interim order passed earlier to continue till the next date of listing. Oh, all right. Yes, next dates will be given, next the rest of the matter. What are you going to? Any urgent matters where interim order needs to be extended? Dates he'll give, dates, there's no issue. Matter where interim order is still today, which has to be extended. He'll give date. Friday may not be, what is the matter? Permission for? It's Friday, good. Okay. Lordship.
Lordship, there is an interim order in item number 28 for stay that may be extended, Lordship.
It is up till today.
Yes, Lordship.
Item 28. Please, interim.
Lordship, item 54, last item. There is an interim may be called.
54.